Well, thank you, and welcome to the 6th meeting of the Columbus Charter Review Commission. I want to thank the staff for its ongoing voluminous and good work to support the work of this commission. We couldn't have come nearly as far as we have, as efficiently as we have, without a tremendous amount of good work. So thank you. This should be a very substantive meeting. We'll try to keep it running as expeditiously as we can. We have a lot to cover. With that, before we get to approval of minutes, are there any opening comments any commissioners have?
Well, thank you.
Okay, so we're on to approval of the minutes of our June 11th meeting, and I might kick it off with a few that Auditor Dorian and I discussed prior to the meeting commencing, and if there are others, there will be others. On page 2, in the third paragraph, or the second full paragraph that begins, Mr. Clark gave a summary of the current rules for speaking before council, et cetera, et cetera. In the second full sentence of that paragraph, it says Auditor Dorian agreed that the rules for speaking before council can be addressed, should be addressed and changed. 6 paragraphs down from that, we have Auditor Dorian asked for a postponement of consideration for changes to the sinking fund and utilities amendments so other sources of revenue could be considered. I would move to strike the next 2 sentences, starting Mr. Curtin asked and Auditor Dorian responded, because the question I asked the auditor and the answer he gave me pertained to a different topic. We really weren't talking about sources of revenue at that point. We were talking about the division of electricity debt and whether any of that debt was a remnant of the trash burning power plant. So rather than try to add context and therefore add length to the minutes, it's really a pretty non-substantive, non-material matter. So if we strike those 2 sentences, I think we will clean that up. And on page 3, in the second paragraph from the bottom, beginning, Auditor Dorian commented on the residency issue. In the third sentence of that paragraph, it says Auditor Dorian offered that the wording could change if, that should be changed, that the wording could be changed to the phrase Franklin County or county contiguous. Those are my recommendations for changes to the minutes. Are there others?
I do have one more.
Mr. Dorian?
On page 4, the second to last paragraph on the page, where it says Mr. Cabot asked if serving on a board, etc. In the second sentence, Mr. Cox replied that the Attorney General has several definitions of what constitutes a public. The word office be in there? Constitutes a public office. I wasn't sure if it was office or officer. Office, okay, so let's insert the word office and so forth. That's all I have then.
If there are no disagreements, those changes will be made a part of the minutes. And if there are no additional concerns or proposed changes, then may I have a motion for approval of the minutes?
Move approval as amended.
Second.
All in favor?
Aye.
Thank you. We are on to our Commission Secretary summarizing the public comments received since June 11.
Yes.
Ms. Blevins?
There and members of the commission, we have had no public comment since our last meeting, so nothing to report today.
Thank you. Now into the meat of the agenda. We are on the always scintillating topic of the sinking fund, Mr. Dorian, and you're the man for that job.
All right, thank you. I'm not looking for additional work here, but the motivation is to try to eliminate some duplicative efforts on the part of different city offices, and I think we can ultimately streamline the service and probably not save any money the first year, but I think in the second and years thereafter, I believe we'll save a bit of money. The sinking fund keeps track of general obligation debt of the city in an identical way that the city auditor does, tracks the dates of required to pay the debt off exactly the same way as the city auditor does. The city auditor does these things in conjunction with the Department of Finance. And I have vetted this argument in the good sense of the word, of eliminating the sinking fund, with the city's bond counsel, with the city's outside financial advisor, and you heard from Mr. Irwin, who is presently the secretary of the sinking fund. I have vetted it with the director of finance and management, Mr. Rakoski, and with the city treasurer, and we all concur that it is an appropriate thing to do. You heard Mr. Irwin rightfully say that the sinking fund also has some investments that they manage in the range of maybe $2 billion, whereas the city treasurer, city auditor, and finance director manage about $1.5 billion of similar type investments. Moving that effort to the current existing code already exists, chapters 321 and 325, so that's already covered, not only the investing of funds, but the sale of investments when necessary. I had mentioned at our last meeting that I think I said I had to eat a little crow because there was one factor I forgot, and it really speaks more to utilities, but also is kind of intertwined with the sinking fund when you think of payment of debt. And maybe I'll cover that in the utility area or here. Let me mention it here. I said to you that in some instances, the different utilities to the city, water, sanitary sewer in particular, garages, pay their own way in this life. However, storm sewer and electricity from time to time require subsidies. So we have included language in the utilities that, again, indirectly affects sinking fund payments, that unless other sources of funds are identified, and I'm very big on this, checks and balances, by both the mayor and the city auditor, that utilities will continue to pay their own way. In my earlier comments, very early on, I had indicated that a change like this, eliminating the sinking fund, I think it would be wise to give it some time. So let us assume that the amendment would pass November of this year. I would like to suggest that the actual change not take place until July 1 of 2015. Otherwise, that would give approximately 6 months for administrative changes to take place and so forth. I'll be glad to answer any questions. Jeff, I think you raised a question about the tax budget and so forth on checks and balances, and I have included both the mayor and the city auditor to address this issue. And then I mentioned at the last meeting that the council president also wanted the city treasurer involved in this, and she is in the new language. So with that, I would ask for approval of the amendment. I'll be happy to answer any other questions.
Jeff, do you have one?
No, the explanation is very clear. I'm just struggling a little bit with matching the explanation to the document in front of me, but that's partly because I didn't get a chance to read these documents ahead of time, and I concur and support with everything Auditor Dorian just said.
Well, thank you, Jeff. I will not be offended if you want to hold this off to the next meeting so you have a chance to absorb it.
No.
But whatever you think best of. I thank you.
Two questions, if I can. Auditor Dorian. One is the proposed July 1 of 2015 effective date in the language, or do we need to amend the language
It
to
is
add?
not in the language that I have submitted, no.
Okay. So I would entertain a motion to unless staff objects and we need more discussion on this, I would entertain a motion to amend in the appropriate place, and I'm open to where that should fit, ensuring that this charter amendment, should it be approved by the voters, would have an effective date of July 1st, 2015.
Thank you all.
Do we need a vote on that? No, that can be incorporated into the amendment. Secondly, Mr. Dorian, a number of us will be out and about answering questions about the work of the commission. If you were speaking to the Kiwanis Club or the Elks or any other lay group out there and you were to explain in 25 words or less what this amendment does and why, what would you tell them?
What it will do ultimately is to eliminate some duplicative services presently being conducted by different offices within the city. Also, we're eliminating an office that is pretty archaic and dates back to any active need all the way back to 1983 in the matter of bearer bonds and so forth, which we're no longer allowed to issue. So my hope is that it will streamline a governmental effort.
Any other questions or comments?
No, except to say that we should somehow acknowledge Mr. Irwin. There aren't many people who will come before a body and say, by the way, you should abolish my job. So congratulations to you.
So noted. I would entertain a motion to propose this amendment to the City Council.
So moved.
Second?
My only question was, I didn't know we were taking that final action
No.
at this time. I thought we were going to put all the proposed changes on the website before we made any official action. So maybe that's just a question for me. Or maybe this is just a proposed
And
change.
that's my hesitation too. I anticipated that we would get all of these in final form, have them published on this website so that people could see them, and then take a final action after that opportunity has been had for the interested public to look at them before we finally vote on them. But, I mean, maybe at our last meeting, we ratify all of the packages. I don't know.
So the question is whether, one, a vote is needed today, and if so, if that vote is to incorporate this amendment into a list of amendments that we will actually cast the official vote on, or whether this is the official vote to recommend to council. Is it the former or the latter?
I think staff's recommendation would be that perhaps a vote to approve this draft language so that we understand that the sense of the commission is not that we would continue working on legal tweaks and that there are no additional requested changes at this time, with the understanding that on the 30th, the commission would take final action on all of the proposals to council.
So basically, it's a two-step process. And the vote today would be to put this in final form for that final vote.
Much like the screening committee and the central committee.
Much like the screening committee and the central committee. So you are asking for a vote then?
If that's the
And
sense of the
I'm
commission.
comfortable with that.
Okay. Do we have a second?
Second.
All in favor?
Aye.
And we're on to Sherry Kish with the utilities language.
Yes, if everyone will remember, at the first meeting where we received presentations, our utilities director, Greg Davies, came in to present on these sections. And section 120 also existed in the sinking fund section because it does have the trustees of the sinking fund in there. And what this charter amendment would do is basically bring the language up to date with not only the utilities that we currently own, but also the processes that we currently have in place. This specifically talked a lot about our water department. We obviously have water, electricity, storm sewer, and I'm missing one more. Is that it? Those three? Sanitary sewer, another one, right. So this would actually just open it up to be more open to have all utilities included instead of specifically water, as well as remove the language specific to the sinking fund. Are there any questions about anything on here?
If my memory serves, Sherry, we're not changing, this draft amendment is not changing city policy relative to how it treats nonprofit organizations that finds themselves in need of some type of forgiveness?
Correct. It allows council to recognize them through a program should they choose to create one.
I would add briefly, I apologize, I would just add briefly that it was council's desire to expand what was permissible under the charter for this particular item, so that we could both have the option of forgiving a percentage of the water bill, as we currently do for senior citizens that meet certain criteria, and this would also be more expansive in terms of the institutions that would be eligible for such a permissive program. Thank you.
And this draft still has a footnote 1 saying, depending upon what happens over here, this may change. Is that now moot?
Page 2 of 3.
Yeah, that looks like it should come back out at this point. Yeah.
You lost me there. Would you repeat that, Jeff?
Well, page 2, section 123, in conducting, managing, and operating the city utilities, the city shall prescribe such rules and regulations as the just interest of the city and consumers may demand, and then there's a footnote. And it says, this recommendation may change based on the draft language for the sinking fund. So we now are past draft language of the sinking fund, so is this language now correct? Got it. Okay. Correct and synchronized with the sinking fund language. So, understanding all of those things, I would move that we make preliminary approval of the utilities sections amendments to the charter.
Is there a second? There's a second. Is there any more discussion, any questions before we call for a vote? If not, all those in favor?
Aye.
And that makes the cut list. And Brian, you're on for ethics.
Yeah, so we, based on feedback from the commission, came back with some amended language. This would, first of all, retain the exception in section 64 relative to the council president serving as the acting mayor. It would place the fact that city officials cannot have any interest or benefit from the contract, job, work, or service other than that person's elective office. Would move that from a qualification section and place it instead into the prohibited acts section of the charter. And then lastly, there was a legal question as to the removal of the term willful as a modifier for violation, and I would defer to Josh Cox on that particular question.
We looked at the various code provisions that are applicable here to ethics, and those are both in Chapter 102 of the revised code and 2921 of the revised code. And each one of those code sections has their own standard. And 2921 it's commonly knowingly. So we felt it was best just to leave it at violation, and each code section speaking for itself as to what the state of mind requirement is for each one of those violations.
So in addition to that, rather than attempting to provide a laundry list of prohibited acts, which would have been even more extensive than the initial list that we had here, we're recommending reference to 2921, which is the bulk of those items that would serve to vacate an office in the event of a violation, and current state law regarding ethics would continue to control as applicable for elected officials and for employees. So what this essentially does is elevate the standard for our elected officials and for our employees here in the city of Columbus.
So just so that I understand then, the word willful comes out.
Yes.
Okay, thank you.
Can I have a follow-up question? When you say this elevates the standard for city employees, can I take that to mean that section 2921 does not call for forfeiture of office or employment under all of the violations?
That is correct.
There are other disciplines or other consequences, I guess, penalties. Thank you. Can you speak to what those other penalties are?
Well, like, for instance, soliciting or receiving improper compensation provides for a disqualification from holding a public office or employment for 7 years. Why that? 7 years, I don't know. But different than the other sections, just provide for different types of penalties relating to the degree of the offense, whether it's a first-degree misdemeanor or felony commission, but not all those provisions have disqualification language in them. So basically, this charter provision would sort of incorporate all those 2921 violations and say if you violate those provisions, you're disqualified from your position, forfeit your position.
I'm not sure I completely understand. Are there violations of 2921 that would not include forfeiture of office?
Under the revised code provisions, that's correct.
But as this is worded, they would require forfeiture of office.
Correct, under this charter provision.
Okay.
Any other questions, comments? If not, is there a motion in support of this draft charter amendment?
Also move.
I will second. Any other discussion or questions?
Well, I'm a bit concerned about that willfulness. I hate to see a good, capable, qualified office holder make a mistake somewhere along the way, not intentionally, but just an administrative mistake of some kind, and lose their capacity to be of service. That I can accept this, but at the same time, I express my preference.
I'm still having a little trouble with it myself. I mean, and I'm not doing a very good job of coming up with an example, but I can anticipate that some elected official might unwittingly benefit from a contract job worker service of the municipality, and it would be almost de minimis, but it would, under this wording, require forfeiture of office. Josh, am I wrong?
Well, I guess when you say unwittingly, that would, I don't know any violation of 2921 that has that standard. Not to be flip about it, but it does require a higher degree of.
But help me here, we haven't set 2921 as our standard. We've said anything that is covered by 2921, yes, but we've said more than that.
Correct, that's correct.
What's the hesitation to following the statute? Which is, it seems the commissioners would have some comfort level with following the current ethics and accompanying criminal statute. What is the hesitation for following that more closely?
I believe that I would begin the answer by saying that under the current charter provision, while it is, I believe I'm using the term correctly, a nullity based on Josh's previous statements, the charter framers intended that if a person had a beneficial interest in a city contract, that they would, by virtue of that interest, lose their job or lose their public office. I mean, that's the current standard in the charter. As we reviewed 2921, we felt, first of all, that, as Josh referenced, the state of mind standards were such that one cannot accidentally take a bribe or accidentally commit theft in office, and those are the types of violations that we're talking about. Intimidation of one's civil rights. Those are items that have, we think, a standard that is sufficient that after a court rules that a person is violated, that it is so serious that they should not continue to have employment with the City of Columbus or serve as an office holder in the City of Columbus. That's the basis of our recommendation here. I will say that many of the sections in 2921 are a felony, and as a result, I believe many of our office holders would not be able to hold office. I believe that's correct. But I would defer to Josh on that.
Well, and I don't have any problem with that. I mean, and I haven't read 2921, don't know what it says, but honestly, I am not having any problem with saying if you violate 2921, we'll impose those penalties. It's just that the language seems to me so sweeping about any shall have no interest, and unless otherwise provided in this charter, any violation of this section, or 2921, right? It's 2921 doesn't concern me. Any violation of this section shall constitute forfeiture of office.
And that section currently applies to all city council members. So the language that you see here with regard to having a beneficial interest in a contract job, work, or service with the city is the current standard as a qualification for a Columbus City Council member.
So if we damp that down, we're weak on crime, huh?
Well, and I'm hesitant to proceed, calling for a vote as long as there are substantive unresolved questions among commissioners. I do think it'd be helpful to look at Section 227. It's very succinct. It's one paragraph. It's been in the code. It's been in the charter since 1982, according to the footnote here. Interest in contracts or supplies. No officer or employee of the city shall have any beneficial interest which interest accrues to the employee or officer by virtue of office or employment in any contract with the city or in the sale to the city of any supplies, materials, service, or land, except on behalf of the city as an officer or employee. Any willful violation of this section shall constitute malfeasance in office, and any such officer or employee shall thereby forfeit office or employment. So correct me, Auditor Doran and Mr. Cabot, if I correctly interpret your concerns. You're not suggesting that we weaken this standard.
No.
Your concern is that the removal of the word willful and the reliance on whatever exists on these various standards within Chapter 2921.
That 1982, I remember the reasoning for that amendment in 1982. I remember a city employee, very honestly, in some division, attended I believe it was an automobile auction, one of these used car auctions that the city has from time to time. And an adversary challenged him and said he was participating in a contract with the city and wanted him removed. He was not an elected official, by the way. He engaged an attorney to bring his defense and so forth. Well, he was not discharged by that. But I'm concerned about that inadvertent. I just think somebody has to express their will to misbehave.
I don't want to be getting all into wordsmithing here, but it seems to me that if we were to say any willful violation of this section or any conviction under 2921, whatever, something like that.
Would you say that again? I'm so sorry.
Yeah. I think we stick the word willful back in, all right? So any willful violation of this section, and then 2921 really takes care of itself, does it not? So I would just reinsert the word, unless otherwise provided by this charter, any willful violation of this section. Or chapter 2921 of the Ohio Revised Code or a successor thereto shall constitute misfeasance in office.
Well, yeah, you could say willful violation of this section or conviction of.
Or conviction under Chapter 2921.
Well, yeah, and again, you can be convicted under 2921 and it not be a office forfeiting offense, is that correct?
Well, if you want to apply the willful standard to any of those violations, then.
I just, somehow I'd like to say any willful violation of this charter and then let 2921 take care of itself, however that works. I'm sorry, I'm not a very good wordsmith on this, and you can,
Do you have legal reservations about that language being part of the charter?
No, just to clarify, our preference is to deal with this legislatively, but if it's going to be in the charter, I have no preference as to what your standard is,
Let me,
whether it's willful or
and
relying on
willful is the
2921.
current language in the charter.
let me ask this. What's wrong with leaving the charter the way it is?
Good question. As we contemplate that, Mr. Cox, can I please ask you, when you said your preference is to deal with this, would you say legislatively
Well,
or
In ordinance.
administratively?
I think the current language in 227, the prohibition is already covered by state law, ethics law. The only thing 227 brings that you don't have in state law is the forfeiture of office for, some of these 2921 provisions have forfeiture, but that's the only thing that you get out of 227 that is not addressed in state code.
Forfeiture of office is not addressed in
Yes.
state code.
Except for, again, I think the only one that addresses that is soliciting and receiving improper compensation
Okay.
has a forfeiture provision, or disqualification provision.
So I just wanted to make sure I understood what you identified as your preference thoroughly. Your preference would be to delete section 227 and just hold city employees to the ethics laws as are written, which are already held by, they already have to follow that standard because they're city employees.
That's our preference.
Okay. So the removal of 227 and the reliance on existing state law. Okay, just making sure I understood it fully.
Comments from the council or administration staff?
I think first, in reference to Auditor Dorian's question, council has a concern that there's currently a qualification provision that applies only to council in the charter. We would be concerned about removing that because we think that that is an appropriate check on the actions of public officials and actually support expanding that provision to all elected officials in the city of Columbus. Secondly, we support what the charter currently provides, which is that certain actions such as unlawful interest in a public contract does result in forfeiture of office. So I think that council would be supportive of what Commissioner Cabot has recommended, which is that the standard for a city official's interest would be a willful interest, and that the standard for everything in 2921 would speak for itself. So we would be supportive of that wording.
And let me just follow up on Mr. Dorian's comment. Wouldn't the current language accomplish that? The current language of 227 accomplish that?
Only with regard to contracts and only in a limited instance. And if I remember correctly, as we talked through this, the revised code standard for an employee's unlawful interest is much more nuanced than this charter provision is. So it actually extends beyond the employee to include an immediate family member or a business associate. It also includes some provisions that would indicate that under a certain set of circumstances, one has not violated that state law standard. So that's why we would support striking the current charter provision with regard to unlawful interest in contracts and instead relying on the language of the revised code by reference in Chapter 2921.
But the truth of the matter is, this chapter of the revised code applies to us no matter what we do. So why make it more confusing? Why create an additional reason to make an explanation as to, why are you doing this? And they don't trust us anyway, quite frankly. So this must be some way for somebody to put something in their pocket or get out of something. It just seems to me that Mr. Dorian's comment makes sense. that if we stick with the original language, and if you have to add something to say, in any contract with the city or in the sale to the city of Innsbruck, I mean, I just wonder what we're missing if we just go with the existing language.
I think there's enough uncertainty and a sense of ambiguity among commissioners that we might want to forestall this one and ask the staff to come back to the commission with perhaps, as I get it, 3 templates that we can consider. One is sticking with the current charter provision and doing nothing else. The other is to go back to Jeff's original comment and using this draft charter amendment as our template, inserting the word willful, and then defaulting to conviction under Chapter 2921. And the third escapes me. I thought there was a third there for a second.
Taking it out altogether.
Taken out altogether, I don't sense, other than from the city attorney's office, there would be much appetite for removing this provision from the charter among the commissioners.
From the administration, we would have a problem with that. I apologize, Mr. Doherty. From the administration, we would have a problem removing something just based on the perception of what the public would be thinking.
The optics would not be good.
Could I offer one additional comment on that? We have 8,500 city employees. Aren't very many of them read the Ohio Revised Code, but there are a lot of them that read the charter. And that's why I feel strongly, I think this is a very good provision in the charter, but whatever we end up agreeing to, and maybe the first time in my career I would disagree with my friend Mr. Cox, but I think we got to have something in the charter. The visibility of it to city employees is very important in my view.
I would second that. I think that's, from my read of the body language around the table, that's a pretty much unanimous view of the commissioners.
Yeah, I would look at the existing language and just see realistically what we get by changing it. So, thank you. Sorry to...
Brian, you need any further direction from the commission?
No, I think we have a good sense of the commission, and we'll be able to come back on the 26th with the 3 templates and some additional commentary on those. Thank you.
Brian and Josh are going to explain the draft amendment on equal rights.
So this document was provided at the previous meeting, and the only substantive change in this draft versus the previous draft is the removal of reference to a contractor of the city. So it would read that no officer, employee, or agent of the city. So that would be the how this would apply. So that would be the only substantive change versus the discussion last week.
I think for the record, it would be helpful to read the entirety of the proposed amendment,
Yes.
Brian, since it's only one paragraph.
Certainly. No officer, employee, or agent of the city shall deny equal access to city services or equal opportunity in employment and promotion or the benefits thereof to any person on the basis of race, sex, sexual orientation, gender identity or expression, color, religion, ancestry, national origin, age, disability, family or military status, or any other status that is protected by federal, state, or local law or ordinance.
Questions, comments?
I think this is laudable and admirable, but in keeping with not putting in the charter more than is necessary, isn't this already accomplished in statutes by the city? City codes.
I would say partially.
Okay.
And I would say also more fundamentally from the council president's perspective, it's been a long time coming for civil rights and equal opportunity for all residents of the city of Columbus. We feel very strongly that no future council should have to face the challenges that this council has faced in terms of referendums or actions that would force us to take back the rights of any protected class in the city of Columbus. We also feel that on the 100th anniversary of the adoption of this charter, this sends a strong message for what we mean to be as a city for the next 100 years.
I think equal rights language tends to be part of fundamental documents, certainly tends to be part, it is part of the U.S. Constitution. There is equal rights language as part of the Ohio Constitution. So we have a history of having equal rights language in our fundamental documents. The question is, as society evolves, what should that language say? Josh?
Well, the policy issues are, speak for themselves, there's no legal reason to have it in the charter, but policy reasons are certainly valid.
Sure.
From the mayor's perspective and the administration's perspective, we've obviously been very forward in our support of any type of equal rights movement, whether it be by ordinance or into the charter. And because of the gravity of this, we believe it should be in the charter.
Other comments or questions?
I agree with Ms. Kish's statement. I think it should be in the charter, yeah. So fundamental that we should put it in there.
I agree.
Do we have a motion?
So moved.
Second?
Any other comments before we call for a vote? All in favor? This proposed amendment will make the list for final consideration. Open meetings and public records. Brian?
Public records is the shorter and the easier of the two, so possibly we'll start there. This would affirmatively state in the charter that the records of the city shall be made easily accessible to the public in accordance with general laws of the state. It simply places in our charter, as many other Ohio charters do, the presumption that city records are open and that the standard is the state law of Ohio.
And how would this comport with what, if anything, is currently in the charter?
Currently, the charter is silent as to public records.
So from a public records, public access perspective, this is clearly an improvement.
The second document before you.
Can I ask a question before we
Yes.
move on? My only question is, as I read that, I don't believe the Public Records Law of Ohio has the word easily. It says it is accessible, and I think it's been made clear by my comments. I'm in favor of tracking the existing law as much as we can, and I just don't think, I think it's 141, uses that word. So I guess I would ask that it track more closely the existing public records law. And I think it does track very closely. That word just jumps out at me because I don't think that's what the statute provides for.
You're right. There is a word in the revised code, but it's not easily. It's another word.
Promptly or something like that.
I think
Yes,
promptly,
I think that is,
or its equivalent.
Promptly available or something.
Is it 149?
Yeah, it is not 141, it's 153.
I'll pull it up while you guys are talking about open meetings.
Thank you. So that would be my recommendation.
Go ahead.
Yes, and certainly, so we can come back to that. Is that okay? When we have the exact verbiage from the revised code. The second item is open meetings, and I'll begin by saying that this is an expansion over current state law, depending on how one interprets current state law. Public bodies of the city shall hold all meetings in accordance with the general laws of the state pertaining to open meetings. In addition to those entities defined as public bodies in the general laws of the state, an entity of the city shall be considered a public body for the purposes of this section if its members are appointed by the mayor or council and the entity has been established and its members appointed by the city for the sole purpose of advising any officer or decision-making body of the city. Josh can speak more directly to this than I can, but the summary would be that there's the open question of whether or not a body like an area commission would be subject to public records, to open meetings laws. I think we've always held that they are, and we've always advised that they are. Council's feeling is that there should be no question that a body like that operates in full sunshine, and that their action should be in public view at all times. Hence our recommendation that we make this addition to current existing state law.
Bodies such as this, bodies such as the one created to study the need for an increase in the city income tax a few years ago, this would send the message that the deliberations of all those bodies are open meetings, subject to open meetings.
I would say also, it does not amend any of the state law standards for what that means for a public body. It simply adds these to the definition of a public body.
This does not call for council confirmation of the appointees.
You're correct, that this particular document does not.
It's just a thought. Do we want it to be, or is that too limiting, or? I certainly support the principle here involved, that
I think one open question that we would appreciate the commission's input on is that I think you would describe this as a two-part test. Were you appointed by the mayor or council? Are you an entity that does these following things? It certainly could read an entity appointed by the city, which could encompass more than the mayor and council. It could encompass a department, and it could encompass the city attorney, the auditor. So something less than a formal council action appointing an individual, and instead an ad hoc task force to study the income tax, for example, if that were not. So just raising that as something for consideration or discussion.
You, in your long memory, have there been study committees or authorized by your office or the city attorney's office and not the mayor and
Well,
council?
I'm thinking of Income Tax Appeals Board. If I remember correctly, I appoint one or two to that. They're not subject, they're a creature of the Ohio Revised Code, by the way, 718, I think it is. But they're not, nothing calls for confirmation by anybody.
That would be a public body in current law.
A public body.
Decision-making body.
Okay. Can't think of any,
So just to piggyback on what Brian said, the city doesn't appoint any bodies. You make it city officials, even though it is, in nobody's memory, it's anything other than council and mayor. You could make it city officials, but
So
city
should we
as an entity doesn't.
amend this to say appointed by elected city officials?
That would cover all the elected officials.
So we would strike the mayor or council and insert by elected city officials? Is that acceptable, Brian and Sherry?
I'm now going to offer a comment that is outside the scope of our work, but because of the requirements of open meetings in state law, there's just going to have to be a training component. If this is a quantum shift for what we're doing now to what we're going to do, people need to really understand what those requirements are, or there's going to be just an opportunity to not meet the standards, and the penalties for such are significant. So that's certainly not the work of this body, but I would offer that a comprehensive training needs to take place, because this is not an easy area of the law to understand, and mistakes could happen very unwittingly, and again, the consequences are great.
I'm struggling to think if there are any conflicts in the code. I'm thinking, Josh helped me out on this, but these appeals boards for income tax matters, then we have the confidentiality clauses that are covering income tax matters. And there might be a conflict there. I'd have to think about that. Otherwise, if I carry out my duties and appoint some people to this Income Tax Appeals Board, which we have, but then I'm also facing confidentiality requirements in the code. I have to think that through. I'm just suggesting there might be a conflict here somewhere.
So people bring their income tax documents to these meetings, they make the case why they should be taxed at X as opposed to Y.
It's usually after they've been taxed and they're appealing a decision by us, yeah. And it's, doesn't happen every day, but it's common. It happens enough. Can we maybe just hold this and let me discuss this a little bit more with with Josh and bring it, again, I fully agree with the concept of open meetings here. I'm
Going to be solving here for unintended consequences.
Yeah. We'll talk about this.
Okay, before we move on to the next item, did you locate the magic word?
I hope so. This section, it's really hard because it's very small on my screen, so I can't tell exactly what section I'm in, but it says, upon request and subject to Division B8 of this section, all public records responsive to the request shall be promptly prepared and made available for inspection to any person at all reasonable times during the business hours. It also says, a public office or person responsible for public records shall make copies of the requested public record available at cost and within a reasonable period of time.
Can I ask you to repeat the promptly prepared and made accessible?
All public records responsive to the request shall be promptly prepared and made available for inspection to any person at all reasonable times during regular business hours.
Is there a reason, Brian, we wouldn't want to just model that language? Okay. Maybe when you come back to us, we can have this charter section on public records comport with that language in the revised code. And on the open meetings, we will look to solve the issue that Hugh properly raises about making sure we avoid unintended consequences on exposing clearly confidential information to public view. And with that, we're on to Recreation and Parks with Sherry.
So what you have in front of you is following up from Alan McKnight's presentation to you last week, maybe, a week ago, which shows that the Rec and Parks Commission appointments would take out the recommendation of the Board of Education, the recommendation of the now existing Council of Social Agencies or its successor. It would keep in the, I'm sorry, I handed it out separately and it's got red on it.
Thank you. Go ahead.
It would keep in the recommendation with the Columbus and Franklin County Metro Parks for one of the board members, but would take out the qualification of that member being qualified in the field of forestry. And remember, that was based on the fact that we do have an entire forestry division and a professional forester on staff. The one part that we struggled with a little bit was the residency piece, which was at the bottom. All commissioners shall be bona fide residents of the city of Columbus or Franklin County. Remember, Alan McKnight brought up that recently they struggled with trying to have someone who was a resident of the city of Columbus but lived in Delaware County, and they wanted him on the commission, and that they were not able to do that, so he wanted to expand it to the city of Columbus. When Alan was in front of you, Mr. Dorian shared that he preferred potentially that there be no residency requirement. The administration and Recreation and Parks would like to still have some sort of residency requirement in for our commission. We believe it's important to have the folks who are making decisions on how our recreation centers and parks are being run have more of a stake within the city of Columbus or Franklin County. I think we're open to looking at a little bit more expansive language for that section, but we would like to have something in there that has some type of residency requirement. So, thank you.
You know, it would seem to me that the original framers of this, or whenever this was amended, which put in the requirement that they be residents of Franklin County, anticipated that this might be a service that would be shared collaboration, involved more than just the city. So that's probably why they said Franklin County, because at that time Columbus was much less than Franklin County. So maybe the same language that's otherwise in the charter for city employees, which has been rendered moot by the state, but says Franklin and contiguous counties might fit in this situation.
I think the administration would be open to that.
Brian?
I think that council would ultimately defer to the administration on this matter.
Other comments or questions about this language? So, do I understand we need to make some language changes to what's in front of us?
What the commission is all agreeing to?
Just so I'm clear, repeat what language in terms of residency we're being asked to agree to.
Right now, you're currently being asked to agree to all commissioners shall be bona fide residents of the city of Columbus or Franklin County, Ohio. And on the table would be a suggestion that it changes to all commissioners shall be bona fide residents of Franklin County or a contiguous county. Assuming that Columbus doesn't jump 2 counties out.
Okay, there's no opposition to that concept from the administration or council. Is there concerns among other commissioners about that language?
You know, I'm not in concrete on my suggestion. It's a thought. I'd be glad to defer to the administration. You know, they're the administrators and operate it, and they probably know better than the auditor does.
So the question before the commission is to modify this language to make it Columbus, Franklin County, and contiguous counties.
And I think what you'll hear from us is even if it does change to something other than what we're suggesting, we'll continue to appoint the way that we've been appointing within the city of Columbus only. So, at least for the time that my boss is here.
And what do we see as the benefit, other than having a larger pool, but what are we seeing as the benefit of allowing appointments from contiguous counties?
I suppose the same benefit that the original language had in saying they could be members of Franklin County. The concept that recreation and parks is kind of a regional enterprise and might be opportunities for collaboration and cooperation with other entities on a larger scale, and so that if there were all the surrounding counties, then that might encourage that.
And if I could add to that, Don, in your absence last meeting, Columbus does lie in 3 counties now. And Director McKnight made it clear to my question, did Recreation Parks provide any services outside of Franklin County? And the answer was yes, in particular Delaware County. So that was driving my thought about the contiguous counties.
Yeah, I mean, they are, if it were Columbus and Franklin County, they are still operating facilities that are outside of that footprint today.
They operate facilities within Delaware County that are within the city of Columbus.
Except for
the reservoirs.
Right.
Correct.
Except for the reservoirs. Hoover and O'Shaughnessy Reservoir Recreation and Parks does maintain land around those facilities that it's outside the city of Columbus.
Correct.
Any other reservations about modifying this language to follow Commissioner Cabot's suggestion about including contiguous counties?
Was this the ordinance, I'm sorry, the language that reflected a majority still had to be from Columbus that we talked about the other day, or was that a different?
We talked about that in a separate meeting with you, just in terms of thoughts and ideas on it. And I think at that point I shared with you that the mayors would continue to appoint from the city of Columbus.
Is there a motion to recommend this charter amendment to make our final list with the modified language?
Yes.
Second.
All in favor?
Aye.
Office holder qualifications, Brian?
So, I think as we discussed, I believe it was the last meeting, we had a desire to bring some uniformity for, in most instances, for the qualifications for office holders in the city of Columbus. There are several small areas where there are differences among the office holders the amendments that you have before you would standardize those expectations with two exceptions. One would be for the mayor would maintain the limitation on holding any other public office or employment. Employment would be the thing that is different for the mayor, and then for the city attorney, maintaining the requirement that the city attorney be an attorney at law admitted to practice in the state of Ohio. So with those two limited exceptions, for the first time, all of the office holders in the city of Columbus would have the same qualifications for office. And I would note that, and this is different than our presentation, based on feedback from the commission, we removed the recommendation for a one-year residency requirement and instead maintain the current charter standard, which is that one must be an elector of the city, which is a de facto 30-day residency requirement before one could be a registered voter and thus an elector.
Questions or comments about this proposed amendment?
One question, if I may. Under Section 66 and 79 that speak to the city attorney and the auditor, I'm just wondering if we still need the next to last sentence. As an example, the city attorney shall be elected for a term of 4 years. Do we need accepting that at the first election under this charter, the city attorney shall be elected for a term of 2 years? And then the same language is under Section 79. I'm just afraid if this thing passes, someone may ask me to leave next year.
That's a very good catch. And reading Mr. Clark's body language, I think he has no problem with amending this proposed amendment to delete the reference to the first term of 2 years. With that modification, do we have a motion to put this on our final list?
So moved.
Yes.
All in favor?
Aye.
And inability of office holders, Brian and Sherry.
Okay. So while this is very long, I would recommend that we look at beginning section 64 for acting mayor. It's probably the best example of a section to look at. This would expand what's currently in the charter. Well, first of all, it would clarify and separate out the idea of the acting mayor versus temporary absence from the city, temporary inability, disability. All those things were sort of jumbled together in a single paragraph previously. So this would separate out and make clear that, first of all, the mayor's actions are permissive, not required, in establishing an acting mayor when he or she leaves the city. For temporary inability, this would state that if the mayor or any other city office holder were unable to discharge the powers and duties of office, and that inability was of a temporary duration, that person or that person's agent would then transmit a declaration of inability to the person that would become the acting office holder. For the mayor, there would be sort of choices there. For city council, there would be no acting office holder. It would simply serve to notify the remaining members of council that that individual would not be present or eligible to exercise their powers and duties while the declaration stood. And then for the auditor and for the city attorney, it would devolve onto the deputy auditor, and what we're recommending is the term deputy city attorney, although in practice it's the chief legal counsel for that office. Once this temporary declaration is sent, and again, it may only be sent by the office holder or his or her agent, that person would sort of devolve their powers and duties to the next person in line. Once it's withdrawn, the powers and duties would return to the elected office holder. We've added one additional statement to be perfectly clear, what's an agent? How are we going to define this? So by the second meeting of council each January, the office holder would provide to the city clerk a notarized statement naming as many agents he or she might wish to. that could act in their stead in the event of a temporary inability. That could be a spouse, it could be an attorney, it could be a physician, it could be any number of people, and it would be purely at the discretion of that office holder to determine who those agents would be.
It's analogous to elective power of attorney.
Exactly. And it also it provides some certainty for the city, knowing that that agent is in fact given this authority by the office holder. And there would not be a question as to whether or not, say, a durable power of attorney for medical reasons would meet this test. I mean, it may or it may not, but there wouldn't be a question now. The more, I think, more important of these two is the permanent inability, because this could ultimately vacate an elected office. So this is the place where we spent, I would say, the bulk of our time and our discussions internally with the city attorney's office and with the elected officials of the city.
Before we get to that,
Mhm.
Brian, because that will consume, I think,
Yes.
the bulk of our discussion of this proposed amendment. Before we leave the temporary inability, am I correct in reading this that we're really adding another person for the first time? If the mayor should choose to designate someone to act in his temporary absence or her temporary absence, we're adding the president of the city council as an option, or has that previously been there? That's in the, okay. Okay, and so under the charter since 1914, it's been possible, should a mayor choose the council president to be the acting mayor, that person has acted simultaneously as acting mayor and council president,
That is correct.
basically being a double-fisted power agent, if you will. I don't think it's ever occurred in my memory. You call a council president being an acting mayor?
Does the council president continue to vote on council in that role?
There's a specific provision in the charter that talks to that too, especially with the dual employment.
You've alleviated my concern. If that could happen currently, and it's been able to happen since 1914, then I'm not concerned about it anymore. I was just wondering if we were adding the ability of someone to assume essentially two offices at once.
Yeah, we have attempted to be very, to make as few changes as possible to the actual line of succession for all of the office holders.
Okay, so we're on to permanent inability.
So this would begin with two things, and I believe that the auditor's point was well taken at the previous meeting, that we need to have a sufficient period of time where the individual has been unable to discharge their powers and duties, and the recommendation here is 90 consecutive days. And that means that the person has literally taken no action that they have the authority to take as an elected official. And then the second sort of test there is that person has not filed a signed written declaration of temporary inability. So if those two things are met, then for the mayor, either the director of public safety or the director of public service. For council, the presiding officer, because if this involved the president of council, this would devolve on to the president pro tem. For the city attorney, it would be the deputy city attorney. And for the auditor, the deputy auditor would request that the appropriate official commence in the appropriate court an action in quo warranto to vacate the office. And that, as Josh or Sherry could speak to, is a very lengthy and involved legal process. If at the end of that process the writ were granted, then a successor would be named as otherwise provided for in the charter.
Well, high school Latin is such a distant memory, Josh, that quo warranto, it means...
Latin, I don't know. My Latin is equally
But the essential nature of a quo warranto action is...
It's a special writ, special remedy that basically is to determine title to an office. And this use here is somewhat atypical because it typically comes up in the context of someone who's saying that they don't have, or that they're entitled to the office. It's somebody else who says they're entitled to the office outside of not an election contest, and saying that that's like...
Who is worthy?
What's that?
Pardon me?
Who is worthy?
Who is worthy?
It sounds like.
So it's, we're just trying to find some legal mechanism or some cause of action that is appropriately designed towards determining who's entitled to an office. And that is, under Ohio law, that's the only real mechanism you have for that. It's quo warranto action.
So it is really the charter conforming to the long-established process.
Well, with the caveat that I'm not aware of other use, of the use of that writ for determining a permanent incapacity or inability to perform an office. Because I think the other instances where you have a determination of permanent incapacity, it's decided by some other body, whether it's the Congress or some other elected body. So in terms of finding a judicial mechanism for making that determination, that, and there is some precedent for that, at least in Los Angeles, that's how they do it.
Can I ask a question I should have asked when we were on section 64-1 for temporary inability? From a procedural lens, if the office holder can name as many agents as they desire, say they name 5, procedurally, is there a hierarchy? Which agent do you go to first? What if one or more agents disagree? How do you procedurally work through that?
I think that's a very good question, and I think it's one that we would need to work through administratively when we got to the point of having these filed. But I would say that I don't believe that there would be the expectation that we'd be approaching these agents and asking them to make a declaration. Instead, they would, of their own volition, be making that.
But I guess I would renew my question, then if one agent came forward, then and the other agents or
Right.
one other agent disagreed, I'd like to know, I'd like for that to be played out, because we may just be creating another, if we don't think it through, it may just be creating another challenge in the future.
Right.
I'd like to ask also, in earlier meetings, I'd expressed my concern about a health professional being involved in this decision-making process. And by the way, I took 4 years of Latin in high school, but Ms. Kish was kind enough to explain Warwinto, what it meant to me, so I thank her. Are we satisfied, and I understand the ultimate decision may be by a probate court judge or somebody in the officialdom, you might say, but are we satisfied that I don't want this decision being made by a bunch of politicians. Are we satisfied that there will be a health opinion evaluation required in this process? I don't know myself, but I'm concerned about, it seems to me it's a health decision, so why not have a health professional involved in that somewhere along the line? I don't know how to answer that, quite frankly. Any thoughts, Josh?
Well, the problem is that, again, this mechanism isn't really designed for that determination. Typically, if you're in probate court, you're seeking a guardian for some other purpose to take over that person's affairs or for a limited purpose, and not for determination of capacity to perform a public office. So I think what you have to do is address what constitutes a forfeiture of the office, a provision like this, and then then the court would make the determination whether in fact that office has been forfeited. But in terms of a health professional being required in this process, that's not, I think currently you can say that is required.
You don't think that we could put something in there specifically binding the court to use that? Because it's our purpose to take it out of the elected officials' hands, other groups of elected officials to make that decision. Our purpose was to try and use the probate court, understanding that they would use the same process that they would use to appoint a guardian by bringing in a medical professional to evaluate.
I think what you'd have to do is determine what constitutes the forfeiture of the office. And if And if that is determination by a health professional that the person is unable to perform the office, then I think that maybe by incorporation, the court considers that as part of the forfeiture decision. Does that make sense?
So we could create a definition of forfeiture that could require a mental state or an absence, or something like that, and then that's what the court would have to rule on, and by putting something with a mental state in could require them to use a medical professional.
I think that's as close as we can come to making it, and ensuring that there's a medical professional's involvement in that determination.
Could a provision in the city charter compel a probate judge on what can or cannot be considered?
That's the problem. I think that's why I think the only way to get that in the process is to make that part of the determination in the charter that what constitutes a forfeiture. So then you have the court making the interpretation of whether that has in fact happened before it makes the determination that that person is no longer entitled to hold that office.
Where's this language, this permanent inability language that we're looking at, unless I misread it? States inability to discharge the powers and duties of the office for 90 consecutive days. Really doesn't say with what level of competence he or she is discharging those duties. It's really silent as to whether the person is sane or insane as they are carrying out their job.
Or whether or not it's even a medical condition.
The challenge that staff ran into in researching this, and this came up prior to I believe it's the 25th Amendment to the Constitution that addresses this. Maybe getting my amendments wrong, is that right? Yeah. Prior to the adoption of that, and this was prior to the assassination of JFK and shortly thereafter, there were multiple congressional commissions that looked at this very issue. Each one came to the same conclusion. There are so many different potential inabilities that it would be impossible to cover all of them, and that the one that would happen would invariably be the one that you did not provide for. And that was why we see in the U.S. Constitution a fairly broad definition, which is verbatim provided here, which is unable to discharge the powers and duties of office.
So the real question, I suppose, Mr. Dorian, is whether we could insert language in this proposed charter provision that would capture your concern or not.
Yes, that's the issue.
Yeah.
Am I being unreasonable here in that search for...
You raise a very valid point. I guess my frame of reference as I think about this is it would be such an extraordinary action. It would be such a historic action for an action to commence in City Hall to, declare a permanent inability. That there'd be such attention, such public focus on it that it's hard for me to contemplate a jurist, a probate judge failing to call upon all the available evidence, health evidence, mental health evidence, any other evidence that's available before rendering a decision of this magnitude. It's really a question of what can you control for and what can you not control for in the language of the charter.
Well, I say some of these factors and languages, they always fall into one of three categories. One that I can embrace, one that I will not accept, and one that I can accept. I'll put this in the middle. We can move on now if you like.
I had just kind of a drafting question in section 64-2. Has not signed a signed written declaration of temporary inability the Director of Public Safety or the Director of Public Service shall. It seems awkward construction to have an option under a requirement of shall. So,
What section are we looking at, Jeff?
I'm sorry, Section 64-2, permanent inability of the mayor. And it says, the Director of Public Safety or the Director of Public Service shall request the appropriate official. So I can just see that a Director of Public Safety said, I'm not going to do it, and the Director of Public Service says, well, I'm not going to do it, and you say, well, the charter says you shall do it, and then they say, yes, but it says either of us shall. I'm sorry, it's perhaps a ludicrous construction, but it just seems that it, you should pick one.
Those are the only two directors that are presently identified in the
That's
city
right.
charter.
Right.
I think that's, when we look back at it, it
Sure.
looked like they're the only, that was the reason why they were the only two selected, because they were the only two when the
Would it
original.
make sense to give the first obligation to the Director of Public Safety and the secondary obligation to the Director of Public Service?
I actually was just sharing with Brian that maybe we could actually change the or to and make it even
Oh,
that
sure.
more
Uh-huh.
significant, that
Yeah.
I've got two directors, that would be, if you
Yeah.
would entertain that, we could change that to
That
and.
accomplishes it, yeah.
Without
Except
objection?
that, I guess, my question would be, except that if they don't agree, then you're still at an inability to proceed. If the Director of Public Safety says, okay, I'm on board, and the Director of Public Service does not agree, and you put an and, you're at an impasse. You still can't proceed and take action.
I suppose for me, though, that's comforting, and this really gets to Elder Dorian's concern. Moving on a provision of permanent inability would be a historic, hugely consequential thing, and having those two directors actually agree that we need to do this is an extra layer of caution, I think.
But if they don't, then we play the scenario out, what happens?
Then we'll call up Hugh and he'll decide.
Well, if there's a mandatory requirement on an individual, you can bring a mandamus action, and you can make them do what their job said, what it says their job is. But again, when it said or, it seemed to me that that's a defense to a mandamus action, because it said, well, it doesn't say I have to do it, it says I or he has to do it. So, I have one other question.
Are we
Whoops.
comfortable adding and, or Marcella, do you want to?
I guess maybe I need a little more time to chew out and think it through, just like with my previous question. What does that look like if we get to that point? What does it mean for the city? What does it mean for moving forward with the administration in the event that we have a permanent inability to serve? So I may just have to think that out of my own mind,
Okay.
which I'm happy to do. I just don't have the time to do it right this second. So maybe we will have to hold it for
And
that.
again, as we crafted this, the three of us again have gone through many scenarios, and we're obviously going from having something that was barely there to trying to get to something that's completely, that will hold up in court. And so it's pretty tough to try and get there. So we tried to get through in that section, the mayor has the ability, then the mayor's agent, then if those two, then you've got two more people. So we're trying to get to a point where by the end, somebody has to do something. There's got to be pretty good evidence at that point that he's really unable to do that.
I should add here on the quo warranto, just since we were talking about the courts, only two courts have jurisdiction to entertain quo warranto actions. That's Court of Appeals or the Supreme Court. So that's, has to be, it would be a panel of judges in either event.
So,
Yeah.
So I have,
I'm sorry.
No, you-
The only thing I want to bring up is that it was my understanding that the Court of Common Pleas was the other court outside of the Supreme Court, and I did not read that. It was just shared. And so I did want to make sure that I shared that, especially with Dawn Tyler Lee, because we did say specifically that the probate court would be who we would be targeting, and under that scenario, that would not be an option. If it's the Court of Appeals, we would not have a probate court option. So that would take out.
I'll double check that right now, but I think we just looked at
Okay.
that yesterday.
We've been looking at it like every day.
Every
so. And then just so everyone noticed, we do have a 64-2 permanent inability and a 64-2 successor to mayor. So that one will be changed to 64-3 successor to mayor.
so here's my other question. because 64-2 doesn't come into play unless there has not been a notarized statement naming an acting mayor. So conceivably, supposedly, a mayor could take office in January, suffer a stroke in February, name an acting mayor at that point, and have that acting mayor serve as mayor for nearly 4 years, as I read this. Is that our intent? Particularly if that acting mayor is an appointed individual and an elected official.
Would be. He or she would be
Unless he appointed the president of council. And in that situation, you would have a acting mayor and president of council, the two-fisted power broker for an extended period of time.
I think we're going to get to recall elections. But that's a good point. We didn't play out a time period for temporary inability in that scenario. So I don't know if anybody has any thoughts specifically on an acceptable time period, but we can look at that.
It's a very substantive concern and a good catch by Commissioner Cabot, and I don't think it's the intent.
Well, at a minimum, it would seem to me that, again, because successor to mayor, if you appoint a successor to mayor, I haven't looked closely, but I assume that person needs to run for the balance of the term if there's an election. And this acting mayor would not have such a requirement. So at a minimum, an acting mayor shouldn't serve past, well, I don't know. I mean, if the mayor is getting better and getting better and getting better and is going to come back, then you wouldn't want to have an election for another mayor. But it just seems to me a curious possibility.
I wonder if we could put in that, well, I'm thinking that maybe even the written declarations are only good for 6 months at max, something like that, because that would give kind of a worst case scenario, because it's 6 months being gone is a pretty long time. But then what would kick in after that? How would you?
See, I'm anticipating that this 64.2 permanent disability is probably never going to come into play anyway, because virtually every office holder is going to have somebody designated to file a temporary disability for them in that situation. But again, should there be some limit to that? Could it go on forever?
It looks like there was some provision, to your point, in the original language of section 64 that says the mayor shall be succeeded in office until the first day of January following the next municipal election. But that was language that was stricken.
Well, but that probably is put back over in this new 64.3 that we just renumbered.
And that's more on permanent disability.
Right.
Permanent inability, not temporary. So you're right, we don't
I
have.
didn't see it there.
But again, I know we spend a lot of time on permanent disability, but in actuality, permanent disability is virtually never going to happen with the temporary acting individuals in place. And that's a more likely scenario, and that seems to me could result in an unintended consequence, in essence, of an appointee of an elected mayor becoming de facto mayor for a long period of time.
We found the one scenario we did not play out. So, point taken, we will think about a time period. Do we want to suggest anything now? My only fear is we've not had a chance to talk to our elected officials, our bosses. They'd probably be upset with me. Okay, perfect.
Are there any other provisions of this proposed amendment we need to discuss before we send it back to the shop?
I can't clarify that. Yes, quo remblo can only be filed in the Court of Appeals, Supreme Court.
You can.
It can only be filed in those two courts.
Which ensures a panel at either stage.
And again, just in regard to that, it seems to me that there might be, well, the next election scenario might be an appropriate time for a temporary.
If the wordsmithing that's going to occur addresses Commissioner Cabot's concern, do we have a sense of the commission that we would want to proceed with this draft amendment, or do we have other substantive reservations beyond that one?
I just want to mention, in regards to the concern about safety director or service director, that might be cured by an and/or. Just think about it.
And/or, yeah.
That's all I have.
No, I think this is an important area of the charter that needs attention, and it's probably never been addressed before because it's so confounding. So, good luck.
Correct me if I'm wrong, too, but I think the panel of judges gives you great comfort on your concern about appropriate health officials being involved.
First I heard of that. Yes.
And if Commissioner Cabot's concern is addressed, then I think we have a sense that we'd want to proceed to add that revised amendment to the list. Prohibited use of public funds, Brian?
Okay. So we come back with some recommendations here in terms of addressing some of the concerns of the commission from the last meeting, in particular making sure that there aren't unintended consequences of this applying, for example, to a public employee's paycheck, making sure that those public funds are not carried up into this. So this would simply say that no funds of the city from any source whatsoever shall be dispersed, nor shall any transaction thereof be conducted to do any of the following. Number one is for a political purpose. Number two is to promote discrimination. Number three is sort of a catch-all of various things, so to expressly advocate for the election or defeat of a nomination or election of a candidate, investigation, prosecution, or recall of a public official, or the passage or defeat of an initiated municipal ballot issue. That's based primarily on current provisions of the revised code that do not apply to us. Section B would say that those funds may be used, this is the permissive language from the revised code, to produce, present, or communicate information about the plans, policies, and operations of the city. All of this is how we currently operate. And then C is that council can declare void any contract. We're recommending may rather than shall in this particular instance because the specific facts we feel really should dictate council's action there, and it should be a more deliberative process as opposed to an automatic voiding of the contract should this happen. There's two footnotes. One is that the diversion for some political uses may apply to us because the revised code does not use the word public bodies, but the LSC, Legislative Service Commission, for the House and Senate has already said that the violations and the penalties likely would not apply to the city of Columbus. And then the first footnote references an item that Chair Curtin raised last week, and that was use of city resources for sort of unsolicited mass communications. We took a look at U.S. House rules on this particular item, franking rules, things like that. I know this will come as a surprise, but the House's rules are very convoluted and complex and cover a lot of different things, but at the end of the day, we think that that is such a complex issue, it's probably best addressed by ordinance versus by charter. So with that, I'd be happy to answer any questions regarding the proposed language.
The first thing I think about when I read this language is it's been common for the city over a long period of time to communicate with the public about bond issues, what would occur, have materials at community meetings about what these bond issues would finance in the way of police and fire and parks and whatnot. If we adopt this language, we're going to continue to permit that. We just would not allow those materials to say vote for and expressly advocate, but certainly explain what this money would go for if voters approve. So we would not be limiting what's been a common practice.
Correct. It would also recognize, the common practice of cities stating the direct impact of the passage of a ballot issue on the operations of the city. So for example, were there an initiated ordinance like in the city of Cincinnati that was similar to Ken Blackwell's TEL amendment, the Tax and Expenditure Limitation Amendment, the city would be able to say these would be the practical implications of that without crossing that line of saying therefore vote against it or therefore vote for it.
And remind me again, what prompted the need to put this in the charter as opposed to deal with it statutorily or in the city code and all those things?
Right. I think staff's recommendation was that there are some things that rise to the level of being so fundamental as a control in the actions of city government that they should not be subject to council action. They should only be subject to electoral adoption. We felt that in this particular instance, limitations on the use of public funds rises to that level, in our opinion, and rises to the level of specific things being so important that we would not want council to have the ability to come back and perhaps change some of these fundamental rules. So that was the impetus for this recommendation.
And it's also because the state statutes in regard to this do not apply to the city?
That is correct.
But again, those are state statutes, not state constitution.
That is correct.
For me, can you explain provision C? I've read it a couple times, but I'm not sure that I'm following it.
So essentially, if you have a knowing violation of this section, and there's a contract involved, so the city has provided a contract to a nonprofit for housing, and those funds were used instead to support passage of a ballot issue. The city would have the council would have the authority to void that contract because of the knowing violation.
And I know you spoke to, at the outset, the permissive nature of may versus shall. But I know we talked about this at a previous meeting, how contracts are voided by operation of law. So this is a case, and again, I've read this a couple times, so I may need to, this is a case where we're actually going below, it seems, the standards in state law.
I believe that the context of our previous discussion was someone having an unlawful interest in a public contract, as opposed to the instance that we're speaking of here, which would be the use of public funds for one of these specified purposes.
And you're right, the previous conversation was on an interest in a contract.
Correct.
So I run a food pantry out of my organization. I have city support to help operate that food pantry. Hughes people catch me using some of those funds to run political operations in my ward or precinct. If that is shown, council can void that contract, and this is a stronger measure than currently exists in city ordinance.
We pick up on your comment about the bond issues that we, every 3 to 5 years, put before the voters. And I know everybody, a lot of meetings held, instructional meetings. All employees are cautioned about asking votes, but many employees provide the information, the brochures and the door knocking and so forth. And I think in particular about the income tax campaign of 2009, well, we had hundreds of employees knocking on doors, and my guess is probably asking people to vote for it. I know I did, and I'm just wondering, would this prohibit something like that?
No, what this one would do is prohibit the use of public funds, so the city couldn't fund the materials that the employees are passing out, but employees on their own time would be able to do those volunteer hours towards that effort.
This takes me back to the conversation we had, though, and I hope I'm right this time, so correct me if I'm not, but when city funds then are no longer city funds. So if these funds were paid by the city for a service rendered, at some point they're no longer city funds. And I think this provision C, if I'm reading it correctly, may go too far in that once I provide, you contract with me, I provide you a service, you pay me for the service, those dollars are now mine. They're no longer city funds. So I think this may be overreaching unless I'm just constructing it incorrectly.
When the city provides those funds, they do so under contract. And that contract expressly describes the service that's going to be provided. And what this gets at is when evidence shows, and audit shows, that those funds are being used for things other than what was expressly provided for in the contract.
Just seems to me that this could be adequately handled in the city's administrative code as opposed to the charter, but it's just me.
And then maybe if what Commissioner Curtin is saying is not what I'm understanding when I read provision C, so maybe the language just needs to change, but.
I mean, if we were reforming something that had to be fixed because somebody'd been abusing this egregiously, then I could understand it, but I don't disagree with the concept, I don't disagree with, we shouldn't do these things, but I'm just not sure it rises to the charter level.
Put this one on hold for further discussion.
I agree with Mr. Cabot's thoughts on that. I think there's a need to express it that it can be handled in the code.
To your point, Jeff, I think there have been cases, and it's not the purpose of this meeting to get into chapter and verse and what those cases are, but I think you would back me up on this. There have been cases where it's a strong conviction of council, the auditor, the mayor's office, that there have been violations of this nature where recipients of funds have used them for wholly inappropriate purposes, and what they're trying to do is solve for that. But
Okay.
I think
I could be convinced, but.
I do think, given the reservations raised that are substantive, we will put this on hold for further analysis and refinement. And we're on to J under 4, and we'll probably take a 5 to 10 minute break after this unless folks want to keep plowing through. J is the council. Brian?
Most of this will be fairly quick to go through because we've already covered it in other areas. So this incorporates items such as 5.1 would be the temporary inability and permanent inability, which we've already discussed. 6 would be the qualifications. 7 is something that we'll be discussing later in the meeting, so I'd ask that we skip that at this point. Section 8 would speak to the meetings of council. The substantive changes there would be that the mayor, the president of council, or any of the 3 members thereof may call special or emergency meetings of the council as provided for by general laws of the state, and striking out the specific verbiage currently in the charter. The second would be to adopt language that we have used previously, although we'll go back and take a look at this, that the minutes and records of the council shall be maintained as an electronic record that is easily accessible and made available to the public pursuant to general laws of the state governing public records. So this is establishing the standard for access to our minutes and records and providing that they have to be electronic. Section 9 speaks currently to both rules and journal of council. We proposed, as we discussed at the last meeting, first of all, that the section regarding the journal be expanded, require that it be a permanent electronic record. So that would place in the charter the retention schedule for that particular item. 9.2 would place in the charter and formally recognize council's authority to organize itself as it deems appropriate through the formation of and rules for special committees and standing committees to promote the thorough and effective conduct of the business of the council. This is in keeping with other sections of the charter which more explicitly provide for the authorities of the given office. 9.3 would be a substantial expansion of council's intended authority in being the judge of the election and qualifications of its members. This would bring us in line with the revised code regarding our authority to punish or expel a member, and it would adopt that language with regard to gross misconduct, malfeasance, misfeasance, or nonfeasance in office, or upon conviction of a felony or other crime involving moral turpitude while in office, or for disorderly conduct or violation of its rules during the term of office. It's our understanding in discussions with the city attorney's office that there have been court cases that have very strictly limited the verbiage that we currently have in the charter to actions that are taken while actually performing the duties of office. So either in a council meeting, at a community meeting. I think the intent was that council would have the same broad authority as any legislative body in determining the qualifications of its members. And this would state that in addition to the other provisions regarding permanent inability, and this is current charter provision, absence from 8 consecutive regular council meetings shall operate to vacate the seat unless that's excused by resolution of council adopted by 3/5 of its members. Section.
Sorry, Brian, did you say that's already in the charter?
Yes, that's correct. That's already in the charter, but moved so that it reads more logically and consistently. Section 10, the president of council. This would, we feel, more adequately address the real world powers and duties of a council president. So in addition to presiding over meetings of council, that the council president would determine the agenda for such meetings, would appoint the chair and members of council committees, and perform such other duties as may be imposed by the council. So expanding this beyond simply this notion of a presiding officer and reflecting instead the actual powers and authorities of that office. 10.1 would better reflect current practice with regard to council president pro tem, and would by separate election, but at the same time, elect a council president and a council president pro tem. That person would act as a presiding officer of council in the council president's absence. 10.2 says if both the council president and the president pro tem are absent, council would, for that particular meeting, elect one of its members as the acting president pro tem. I think we've covered previously, and the commission has supported section 11 and all the subsections there with regard to the city clerk and his or her powers and duties. Section 12, public defender, at the recommendation of the city attorney's office, we recommend striking this item. This was an item that was considered by the 1993 Charter Review Commission. At that time, their feeling was that while it was a moot section of the charter, it was a permissive section of the charter, and they felt at that time that it had not gotten to the place where it should be removed, but actually stated in their report that a future commission might feel differently. We feel that enough time has passed and it is still a moot issue, so we're recommending removal. The city treasurer section, I think we've already covered as well, simply brings some continuity in that individual's powers and authorities, as well as the city clerks as appointees of council. Section 14 would move the current provision in the charter regarding council's authority to appoint officers and employees of council as it deems necessary, and that it sort of clarifies a current provision of the charter that council's limitation on exercising any other power of appointment is with regards to officers and employees, except as otherwise herein provided. So that's a current charter provision which we've sort of clarified. 15 we can skip at this point because again we'll be discussing that later in this meeting.
Brian, I think Auditor Dorn has a question.
Thank you. If we could back up to probably before Mr. Cox, the section 12, the public defender. Who is it that hires and fires public defenders?
Well, the court contracts with the public defender to provide those services.
Which
so the
court?
contract is with the municipal.
Municipal court does. Because then we put money, we have contracts with the public defender organization, do we not?
Well, then, of course, the money for the court's contract comes from primarily the city.
Right.
And we authorize that, council authorizes that contract.
Okay,
But the contract is not.
well, when one thinks of a chain of command, the public defender responds to the court, not
Yes.
to council.
Correct.
That's, okay, thank
And
you.
the Office of Public Defender is an arm of the municipal court.
That I'm not sure.
Well, there's a public defender commission, I believe. And the public defender provides representation at both common pleas and municipal court. There are two divisions within the public defender's office.
Right, yeah, if it was a division of the court, they would need a contract, so, yes, that's a separate.
You know who appoints that commission? I don't think the mayor does. The mayor's not involved in that, is I think.
I think it may be the county commission,
I don't know.
but it may be the court. It may be, each court has seats on the commission.
We'll get an answer on that. Sorry,
Well,
Brian.
the reason I pursue the question is I'm still, where's the mandate that the city provide the money? It's a combination, city and county. But I'm trying to put my finger on where's the direction or the law that says the city's got to put money into this as opposed to the county or.
It's not the
Ma-
charter, right?
I mean, a lot of contracts, I know that, but, well, maybe you can think about that, would
Well,
you?
I think it goes back to our ongoing issues as to the city's basically the purse of the court, but not the controller of the court.
Is it still like an 85 to 15 split?
Parts of it, some of the salaries and so forth. Yeah. And it's not strictly 85-15 anymore for judges. Judges in Muni Court, I think, get 3 paychecks. They get a check from the city, they get a check from the county, and then the most recent, several years ago, when there was, the legislature granted a pay raise, they get a check from the county, because the legislature agreed to pick up that pay raise, so it's strange.
Mini tutorial on the
Yeah, right,
It's,
one you didn't want.
Rube Goldberg here. Brian?
Like I said, 15 we can move past at this point. If you move to 17, simply striking that language because it's been reinserted previously in the charter. 18 would provide that an ordinance or resolution that has been adopted by the council shall be maintained as a permanent electronic record. So again, making sure that we're permanently maintaining those items. 19, ordinance enactment would allow for the introduction of ordinances in electronic and digital form. In practice, this is what we do currently. We are, for all intents and purposes, a paperless council at this point. So, Section 33 is investigations by council. As we shared previously, the charter currently would appear to state that only a council member, him or herself, or a committee made up of those council members could conduct an investigation. That's not a limitation placed on the other investigative powers in the charter, so we're simply recommending that council have the ability to do that.
Question on 19. On 19, I'm a bit concerned about the new language that states, except further that an ordinance placing a charter amendment before voters may contain more than one subject to be amended and submitted as a single ballot issue. Does that fly against our one subject for the purpose of clarity issue, combining different subjects into one ballot issue? I thought here, among us here, there's somewhat of an agreement if there are like purposes or like alliances, we could combine those, but we wouldn't. I'm worried about this being too broad. Otherwise, would we put combine on a single ballot issue something that affected the public safety and at the same time affected the city auditor's office or city treasurer's office? Seems to me they're kind of disparate role players and duties. Anybody else share that concern or am I?
This language is permissive, and you will always weigh putting everything together and having it be too much and then being turned down, as opposed to breaking it up into manageable and related pieces so that you have a cogent vote on it. So given the fact that it's permissive, I'm not as concerned about it. And there may be a day when you want to say, this is all our charter amendments, and they are all routine and non-controversial, and so we put them all together. But I can't imagine that being the result of this group and this effort.
Yeah, I can share that the genesis of this was a case out of the city of Cleveland in the 20s, I believe it was, where the city, for all intents and purposes, enacted a new charter. And it was initiated by city council. It was not initiated by a vote of the people. It repealed every section of their charter, reenacted multiple sections, reordered the entire charter, but it did fundamentally alter their form of government. And they made the decision to place that entire item before the voters because any individual section being, rejected by the voters would have created internal inconsistencies in their charter. So had they been required to operate under a strict understanding of a one subject rule as being one subject of a charter amendment equals one ballot issue, they could not have amended their charter in that manner. So that was the genesis of this recommendation.
I think Hugh's point is well taken, that the desirable state is for unlike provisions not to be melded into one provision going before the voters. However, it's really, I think, a councilmanic decision to determine when there is a logical nexus and when there is not a logical nexus between different issues. And I think, quite frankly, it's something you almost have to leave to the discretion of council. I think this this draft charter amendment looks like it's going to be going back to the kitchen for a number of other reasons anyway. We may ask Brian, the staff, to take a look at that to see if there's any way to wordsmith it a bit to show that the intent would be to only combine, like issues, but not restrict council's ability to determine when there is a logical nexus in its estimation.
And I believe the last item there would be striking section 145, which is the Bureau of Information and Publicity, which we previously discussed.
I would like to renew my comments related to the closely tracking of 149 for public records and take out this word easily. So whatever language has come up with from the previous discussion, I see that language here in section 8, 9.1, and 18.
Any other comments on this proposed amendment? It's a large one. We've covered a lot of territory. Brian, could you refresh our memory briefly on what we're still solving for in this amendment?
Let's see, so I believe that we're good on vacancies. I believe that 51.1 and 2, as with any other inability section, would be further honed in on. I have to go back at my notes. I don't believe that there were any additional questions about qualifications.
We're going to be removing the language about probate, correct?
Yes. Let's see here. Any other items? the public defender will be able to provide some additional context for how that public defender comes to be and how they're funded and things of that nature. I think at least I would state that what I believe to be germane to the discussion is that council does not actually appoint an individual as a public defender. And I think that's what we're addressing here. And then obviously we have some other items that we'll discuss later, but we'll take a look again at this proposed language regarding the placement of a charter amendment before voters. That's section 19. And I believe that captures the items that we've been asked to review. And obviously the issue easily.
Thank you.
Before we move on to number 5 on our agenda, I would ask if there's a desire among commissioners to break for 5 to 10 minutes.
Yes.
I think so.
Okay. It is 3:02, and we resolve to be reconvening no later than 3:15.
Whenever you're ready, guys.
Thank you. Need to press your
We-
buttons.
Yeah, we need
All buttons need to be on
green.
Brian, I was curious about your earlier paperless comment.
To 5B and do B first and then back to A. And so with that, we have Mike Eckert from the Civil Service Commission.
Thank you, Commissioners. As I'm sure you're aware, the Charter Sections 146 through 158-1 provide for the overall structure and responsibilities of the Civil Service Commission for the city. For today's meeting, we're just bringing before you for consideration and inclusion in the overall update language, a seemingly small but important change to Section 149. For context, let me share that the City Council strives to be an employer of choice through the implementation of effective recruitment and retention processes, which include such things as ensuring there are efficient, inclusive mechanisms by which current and former employees can be considered for employment and classifications.
Mr. Eckert, I'm sorry to interrupt. Can you tell me what you're reading from? I can't find the
You know what?
document.
I'm sorry. It's entitled Time Limit for Reinstatement to Eligible List, a single page. Sorry about that.
That's
And make sure
okay.
you have
Thank
the
you.
one that has both the verbiage that I'm referring to and the current and proposed language on the back. Sorry about that.
So we have 2 pages in all.
Yeah. Or one page, 2 sides.
We didn't
The
steal
one
your
that's-
copy back.
Yeah. All right. One of the mechanisms we've got in place, currently authorized by the charter, is the opportunity to reinstate, for individuals to reinstate to an eligible list for classification to which they were previously appointed. While this reinstatement does not result in an employee's guaranteed appointment to a position in the class, it does provide an appointing authority the opportunity to consider the former class incumbent without diminishing his or her pool of other certified eligibles from which to make a hiring selection. Currently, Section 149K of the Charter requires that the Commission shall prescribe, amend, and enforce rules for the classified service, that the rules shall provide for reinstatement on the eligible list within 1 year of persons who, without fault or delinquency on their part, are separated from service or reduced in rank. In May of 2000, in an effort to enhance employee retention and eliminate any potential artificial barriers to reemployment, the Commission did amend its Rule 8C1 to allow individuals who have left city employment to request reinstatement to an applicable eligible list within 3 versus 1 years from the date of separation. Our recent review of the charter provision applicable specifically to the Commission revealed a potential discrepancy with the rules in the permitted reinstatement period. So Commission management in collaboration with the City Attorney's Office believe it's necessary to have the Charter and Commission rule in sync in this matter. So although potentially contrary to existing Charter language, for the past 7 years, the Commission has afforded employees the opportunity to reinstate, meaning no new testing is required, and remain on an eligible list for a job classification to which they were previously appointed, up to 3 years following their separation from city employment. This practice has resulted in the inclusion of additional candidates with a city work history for which appointing authorities can consider and make hiring decisions. Because this practice has proven to be beneficial to the city employees, Commission management is recommending a change to charter language allowing the reinstatement to an eligible list within 3 years of termination from city employment. That's it in a nutshell. On the back of the page, you'll see the actual top one is our current language, and the one small change in the second paragraph there is the replacement of 1 with 3. Be happy to answer any questions you have.
So you're asking for the charter language to be changed simply to comport with what is current practice?
Correct. And I mean, certainly we could change the rule back, but what we found is this additional time is beneficial to the city as an organization and to its employees, and having to retake tests to get on lists to be appointed to classifications which you previously held seems redundant and bureaucratic.
Is it possible to estimate how many individuals are affected by this on a year-to-year basis?
It is going to be a guesstimate. I'm going to say between 75 and 100 may request reinstatement to a list.
So it's certainly not a de minimis number that...
No, and we do, current employees actually request reinstatement too. It's not just individuals who have left. The rule provides for that. But if I have been in classification A, and then I move to a whole other classification that's not part of that class series, or even job family, so I'm now in B, and for whatever reason I decide, you know what, I enjoyed my work better, or it's more opportune for me to go back to A, this is a mechanism by which those individuals can get back on the list and be considered. And it is important. Going back on the list does not guarantee their reemployment in that classification. It merely provides them a mechanism to be considered, and the appointing authority has the ultimate decision there. But they're not included in the count or numbers of individuals provided to the appointing authorities for consideration.
Questions or comments for Mr. Eckert?
This seems to me to be way too much detail for the city charter, and I'm wondering why we're not trying to take a bunch of this language out.
Well, I think the Civil Service Commission, Mike, you could talk to this more. They've been charter-driven by a lot of what they've done, and that's what they've always gone back to, and it's always remained there. When we did a review of this, given the voluminous pieces that we're sending you already, we thought it best to go ahead and dive into exactly what may be a direct issue for us, and this one was an issue that we caught, and we thought this was most beneficial to bring forward to you immediately. I think that as we go ahead and set these charter commissions to look every 10 years, that we'll spend the next 10 years looking over what the Civil Service Commission does and how it operates and what else could be changed in that time period. Just given the period of time we were looking at now, we wanted to focus on the very specific issues that we knew were in direct contradiction to what we were actually doing in process now.
It's just a guess, Jeff, but this charter is a product of really the height of the progressive era. And there was such a concern legitimately over the patronage spoil system, the rank excesses of the antithesis of civil service, that the framers of the charter at that time period wanted to nail down in the concrete of the city charter the provisions that would be followed for the hiring and retention of city employees, and that would be my guess as to why the framers wanted civil service provisions in the charter and not anything weaker than the charter. But we live in a different era now, 100 years later, and your question is valid. Is it having these provisions in the charter is fundamentally important today as they were back in the height of the progressive era when we were coming out of arguably the dirtiest era of American politics.
And you're speaking, I'm sorry, as to specific provisions or?
Well, I could conceive of a civil service section of the Charter, 149, that says, "The commission shall prescribe, amend, and enforce rules for the classified service," period. Do the rest of it as work of the commission. The details.
Yeah, certainly that'd be possible. I mean, I think there's some value that things have been specifically identified, ensure that they're not easily taken out or manipulated in such a way that could be detrimental, or that we would lose something.
Or again, the administrative code of the city could detail some of these details. I'm sorry, I'm not being very articulate.
However, that would take it out of the purview of the commissioners, I would say. And I think part of the thinking here is, the commission does not report directly to an elected official. And that's done with purpose and intention. And has served us well, I think, these many years.
And apparently the charter doesn't really matter, because for how many years you've been doing this in violation of the charter?
Possibly.
Don't answer that.
I was going to say, choose your words very carefully.
Well, following Auditor Dorian's three-part test of ditches he would die in, ditches he would not die in, and ditches he's totally ambivalent to, I mean, where does this fit in your scheme, Jeff?
I can go along with making the charter comport to the reality of today. I just think that this section of the charter is worth a much more in-depth look than we're giving it at this point, and maybe that's all my recommendation is. But and I understand and appreciate the history of where we were 100 years ago and why this was necessary, and just think it's worth a look. On the other hand, if we want to fulfill our charge and be adjourned by the end of June, my guess is we're not going to get around to this.
What is the will of the commission on this?
I can accept the change.
Michelle, Dawn?
I'm fine with the change as presented.
As am I.
Do I have a motion to add this provision to the final list?
So moved.
Second, whatever.
All in favor?
Thank you all very much.
Thank you.
Thank you, Michael. So we now take one step backwards, not literally, but on the meeting agenda to 5A, which is office holder compensation, which is certainly a meaty issue.
Indeed. Probably try to summarize some of my comments here for the sake of time, but let's say that, like several other large American cities, Columbus currently establishes compensation for elected officials by ordinance. While there's great variability in the way that salaries are established across the nation's largest cities, several emerging practices attempt to balance the desire to remove any perception of politics in setting appropriate levels of office holder compensation with the need to maintain accountability to voters. Staff suggests the Charter Review Commission recommend adoption of a citizens commission process to recommend salaries for the city's elected officials to adequately address those issues while requiring council action constrained by those recommendations. So currently, our city charter states that all the salaries of the officers and employees of the city are established by council ordinance. There are some restrictions on council's discretion there. First of all, council members may not be paid less than $4,800 a year. That's $4,800, not $48,000. Salary for officers and employees must be uniform for like service. Changes in salary may not be made mid-term. The mayoral salary may not be less than $5,000 a year, and the mayor's salary must be set at least 1 year before the start of a term. So in line with these provisions, we've made past periodic ordinances. Currently, the salary for everyone other than the mayor is set through 2017. For the mayor, it's through 2019. The city has used processes like a paid consultant to review city employee salaries, do a market assessment, and then make recommendations back to the city for their service. But I would point out that the charter, however, does not require the council consider any objective factor in establishing it. Really, council's action is constrained, as any other legislative action would be, to the court of public opinion and the power of the ballot box. So we reviewed the nation's 30 largest cities. We also reviewed Ohio's 7 largest cities that are not in that list. And it became very clear that cities have been and continue to wrestle with these competing goals of limiting elected officials' ability to set their own pay while making sure that they can hold someone accountable when that pay is set. Not an easy balance to reach. And in fact, just a historic note, this goes all the way back to the passage of the Bill of Rights to the U.S. Constitution. There is still one proposed amendment that is still hanging out there and has never been ratified. What is now the 27th Amendment to the U.S. Constitution was actually proposed in, I believe it was 1787. It was passed in 1992. And that establishes that Congress cannot change its pay midterm. There has to be an election between the vote and the time that the pay changes. It gives you a sense of just how long it took for us to come to some agreement on that particular issue. So while this has led to a lot of variability across the nation, we're seeing a move towards an arm's length citizen process that at least makes a recommendation on what salary should be, so that there is a constraint on the legislative authority of the city in establishing those salaries. We have a table here in the middle of the page. I'm looking at one with much larger font, so I can't tell you what page number you're on. But essentially, out of these 37 cities that we looked at, 16 establish elected officer pay by ordinance of council, 9 have a charter provision, 8 have a commission recommendation, and 4 follow state law. I always caution that when we look at other cities, we're not really looking at best practices, we're looking at common practices. And that's because there's so much variability in the way that those cities' governments are structured and the home rule authority under which they operate, or in some instances, the lack thereof. So primarily in southwestern cities, and you see this especially in Texas, they're not big fans of elected officials, and that's reflected in the way that they constrain those officials' pay and authority. So there is an expectation for most city councils, for example, and mayors in Texas, that they will be working part-time and that they will receive minimal compensation on a per-meeting basis. So that's reflected in the way that they establish charter pay provisions. If you look at cities that use state law provisions, these are primarily in cities where the city charter is a creature of state statute, or where home rule provisions are significantly more restricted than they are in Ohio. Citizen commissions are gaining steam across the country. This year, voters in Minnesota will consider a change to their constitution that would establish a commission like that. Commissions that establish office holder pay exist in 19 states already. In each of these instances, voters have affirmed their desire to remove some discretion, but also in each of these instances, they want to hold elected officials accountable.
Brian, if I can ask one
Yes,
question there.
certainly.
Say similar processes have already been established for state officials in 19 states. I would assume that those commissions don't set, but they recommend?
That is correct.
Okay.
It is a very rare instance where a commission would set, and that is the final word on the issue.
In most instances, the final word is left with the elected officials.
That is correct. In most instances, the final word is left with some legislative body. So at the state level, the state legislature, at the local level, the village, or the city council. The charter provisions that we looked at most closely are the ones that provide for the sort of citizen-initiated or citizen review. And those are Baltimore, Dayton, Detroit, Phoenix, San Diego, San Francisco, San Jose, and Toledo. We have the opportunity, if we follow their lead, to embrace greater public involvement in the process of setting public official compensation. And we can also maintain the core principle that at the end of the day, elected officials have to stand and be counted. They have to be held accountable for the decisions that they make. So to facilitate the consideration of this, we have taken the liberty of providing some draft language to go through with the commission so that we can sort of better lay out the thought process of what a citizens commission would look like. Currently, Section 7 of the charter establishes salaries for council, and I said before, $4,800 is the limit. Section 15 which establishes how the salaries of all the elected officials are established. It does not specifically reference the auditor and the city attorney because there are not provisions in the charter specific to them. So it would be a unnecessary reference in the current charter. It would become necessary if this were adopted. New Section 15.1 is where we would get into the establishment of this Citizens Commission. So essentially the way that this would work is that there would be a 5-member commission. They would have to be qualified electors of the city, could not hold an office or employment with the city, and would serve without compensation. We would recommend that if this moved forward, that it be modeled after the Charter Review Commission, where 2 members would be appointed by the mayor, 2 by council, with the mayor and the council jointly appointing a chair for that entity. We would recommend, again, if this moved forward, that it would begin at the second regular council meeting of 2018. The purpose there is that it gives us sufficient time after an election for the person whose pay may be affected in the next office to have some representation and say in that process. Vacancies, as with any vacancy, would be filled as prescribed for the original appointment, and we would specifically state that the meetings and records of the commission would be open to the public. The duty of these commissions, and this is consistent across the board, is to conduct a comprehensive review of salaries for like positions in the public sector, with the idea being that they can come back and provide recommended salaries that are appropriate to the duties and the responsibilities of each elective officer of the city. It is fairly typical to provide in these city charters a very brief window within which to act so that the commission's work is focused and it moves from this commission phase to the legislative phase. So 3 months seems to be a fairly typical amount of time after which the commission would submit their recommendations for a base salary and would include an annual cost of living. One of the common practices that we identified was some limitation on those annual cost of living adjustments so that they truly are cost of living adjustments and not raises. One of the things that we looked at here was considering the average increase in the CPI for the preceding 4 years. Were this to be done this year, that would mean that the annual increases could not exceed approximately 1.92%. The commission report, after it's submitted, would be forwarded to the council. If they did not submit a report, council would have the authority to compel a meeting for them to do what they've been established to do. Council would then have 30 days after the report is submitted to, by ordinance, either accept the commission's recommendations or any part thereof or reject it. If council rejected the commission's recommendations, the salaries then, in effect, would remain in force. However, there would, yes.
Questions? I want to make sure I'm clear on this 15.5. So within 30 days after the report is submitted, council shall by ordinance either accept the commission recommendations or any portion thereof. So I want to make sure I understand that the commission might come back and say you get X, but the council has the authority to say we'll give you less than X?
That would be correct.
Or they, I can't imagine them ever rejecting the recommendation and leave things unchanged. But in no event, the council could adopt an ordinance establishing salaries which exceed the recommendation of the commission. Is that correct?
Yes, that's correct, Auditor. The intent, and this is again modeled after the other cities that we looked at, is that the committee's recommendations would be a ceiling, not a floor. So the council could never, in any event, exceed those recommendations.
The reason I asked the question about or any portion thereof, it's not very well known, but I can tell you there have been a lot of elected officials, including some council members, who have waived pay raises, especially during the very difficult years. But, okay, thank you. That's good.
Brian, would this language allow council, upon receiving the recommendations of the commission, to say, we're going to give the raise to the mayor, we're going to give the raise to the city auditor, we're going to give the raise to ourselves, but we're not going to give a raise to that daggone city attorney?
We would never do that to the city attorney.
But this would allow.
But it would allow us to.
Yes.
Really, it's no different than the power the council currently has. In fact, I would say that this provides less discretion to council in terms of having a more public process to publicly debate what we should be paying our elected officials. It would provide a 30-day window for council to act by ordinance. That ordinance, of course, would be subject to the referendum, as other ordinances would. And I think that it would establish an expectation that council would act reasonably and appropriately in the face of citizens who have said, this is our recommendation to you for elected officials.
Who do you, I'm sorry, Mr. Chair, if I may, who do you envision would staff this council?
I think that there's a lot of variability in that as you look at other cities. So in some cities, there's actually an appropriation in addition to the appointment so that the commission can hire its own staff, hire its own, consultant or researcher. There are other cities that would require sort of a broad cross-section of various departments with expertise in this area to provide that expertise. But really, I would say the most important thing is that these are arm's-length commissions. So they really do have broad discretion to say, you know what, we appreciate that you want to provide this expertise, but it's not one that we need. Or to request from the council that there be an appropriation for that specific purpose. While we have not included it here, and I don't feel that it's necessary, there are some instances where the charter speaks to providing funds as necessary for the duties. It's not something I would recommend as an addition, but it is something that's been done before.
I agree with the arm's length nature of this, the appointments by the mayor and council and then one jointly. What I fear, and I can accept this, but I fear the poor being left out of this equation. If I'm going to appoint someone to set my salary, I surely want that person to make a whole lot more money than I do. And that's where I see, I don't know if there's some way something could be incorporated to ensure some broad range of representation economically or some way. I don't know how to do that. I'm just expressing a concern that I have that the poor will be left out of this equation. But I can accept this language.
Other comments, questions?
The annual cost of living adjustment which shall not exceed. I don't know what this salary commission might decide, but they might decide that council members are woefully underpaid. And therefore, we're going to raise it a lot, or recommend raising it a lot. But maybe rather than raise it all at once, we would raise it in 2 or 3 or 4 steps, which would be prohibited with this cost of living cap in there. So I don't see a need to put a cost of living cap in the charter. I think that, again, the salary commission and the council ultimately, the council ultimately has to live and die and win re-election or not based upon what they did with their salaries. So I think that's an unnecessary additional few words in the charter. Other than that, supportive of the concept. It is, although the average person thinks it's a wonderful thing to be able to set your own salary, in fact, it is a huge political liability, and most of our politicians who are in that situation are woefully underpaid because of that, so.
Jeff, are you suggesting that the commission then identify the incremental steps?
They could.
Like X the first year, X plus 1, X plus 2, and that type
And
of
the
thing?
commission might say, you know what, we think they're fine, but they should keep up with inflation, so we would recommend a price index that is the cost of living. But don't have the charter require them to say that. They might say, you know, we think that these council members aren't paid enough, but rather than have it be one big increase at one time, we'll split it into 4 steps of getting there, something like that.
I think that's a point well taken. My sense is that having a COLA designation in the charter is probably something best left out of the charter, and the commission would have the authority to do or not do that. Any other?
Well, the good thing about that, the COLA in that respect, is that it does put a cap on it. It does put a cap on the increments.
I think that the administration actually asked for that to be placed in there specifically for years 2, 3, and 4, so that we could show that we do have some restraint there and do have an ability to cap off where the raises could go. Understanding, though, that the first year would be the base salary that could be set at a different amount. But I understand the reasons that you've brought up, and they make sense too.
I agree with Commissioner Cabot's observation that $50,000 is not a big salary for someone who's actually diligently, dutifully doing the work of one of 7 members of the council of a city this size. But to Auditor Dorian's point, if you're living in poverty, $50,000 looks like an awful lot of money. And I would say the political process governs those considerations, and I think the political process has historically served to keep salaries in a relatively modest state for city council members and for the other elected officials of this city. I think if you look at the talents and the expertise and the work required of all of our elected officials in the city of Columbus, that the salaries are modest at best. Is there a sentiment on the commission on what we should do with this proposal at this point?
Well, I'll just reiterate that I can accept this with the COLA.
Okay.
I'm driven by the cap idea, quite frankly. Put a limit to it somewhere.
Jeff? Well, I still think...
You know, if you're gonna impanel a commission, and if you're gonna give them a charge, then you should give them some flexibility and authority to meet that. And again, the council doesn't have to adopt the commission's recommendation. The council can adopt less. They just can't adopt more. So I think putting the cost of living in the charter doesn't make sense.
Marshall?
I'm inclined to agree with Commissioner Cabot's analysis. The checks and balances is that it doesn't have to be accepted. So I would vote to remove it.
Dawn?
I'm supportive of removing it.
I just want to make sure I understand, removing the CPI?
The COLA or the cost of
Removing the
living.
COLA?
Yes.
Okay.
Would the administration, the council, want to proceed with a vote of this commission at this point with the draft amendment not having the COLA in it, or would you rather send it back for more discussion, deliberation, and education of the commission?
Yes, I will definitely need to speak with the administration on that.
Okay.
So we would like to
take this back to the
pull that
council.
for, let us go ahead and have that conversation one more time.
Okay.
Thank you.
Is there any other discussion on this proposed amendment before we send it back to the kitchen?
Only that, however it turns out, I can live with that. I think it's a needed and important mechanism. So I support the concept. We're just talking about the details.
It might be helpful just to have a mini memo, if you will, on the COLA, the pros and cons of having a COLA or not having a COLA in the charter language. I think the administration and Auditor Dorian certainly have a very valid point. The three of our commissioners have a very 180 view of that at this point. Elections.
All right. Looking at, I think with 11 minutes left in the meeting, if it's okay with the chair, I'd like to provide sort of the general overview of this particular item, but because of the amount that needs to be gone through on this particular issue, perhaps that'd be best addressed next week for the specific language.
Unless the commissioners and staff would rather go beyond the 4 o'clock time frame and try to deal with this issue at this point. Is there a sentiment on staff, on the commission about foreseeing this issue or plowing ahead and running late?
I have to be someplace at 5, that's all.
Okay.
I can make a telephone call 4:15, but Brian can still keep going. For the 5 minutes I'll be out.
Do we run a risk of jeopardizing anything by pushing it back to our next meeting?
I think our preference would be that we cover it at this meeting,
Okay.
if at all possible, but we wanted to be mindful of the commissioner's time.
Okay.
So, and I think you'll see why with my opening remarks. So, it really is difficult to overstate the importance of this commission's deliberations on the charter provisions of the elections provisions of our charter. The right to vote is the bedrock upon which our city government stands, and from the right to nominate and elect every elected official in the city to the various mechanisms available for Columbus residents to hold their government to ultimate account. Our government thrives when our citizens have the rights and responsibilities associated with free, fair, open, and honest elections. The city's first charter commission was acutely aware of the power of the ballot box. In fact, those citizens devoted more time and attention to elections than any other issue in their deliberations. There's a footnote there that they did have a lengthy discussion about how hot it was and waited until September to start back up again, but that was just one discussion. Many of their progressive proposals arose from the need to reserve to the people the basic voting rights which make good government possible, overturning the spoils system, giving every elector the right to vote for every city official, and expanding opportunities for citizen engagement in their government. As we previously discussed before this commission, struggles over fundamental civil and political rights have frequently turned on securing unfettered access to vote. 8 years before passage of the Voting Rights Act, Dr. Martin Luther King stated, "So long as I do not firmly and irrevocably possess the right to vote, I do not possess myself." And in that same year, then Senate Majority Leader Lyndon B. Johnson succinctly stated that this right to vote is the basic right without which all others are meaningless. On the 100th anniversary of the adoption of our city charter, this Charter Review Commission has the opportunity to modernize our charter's election-related provisions, and in the process, the mechanisms through which our citizens lay full claim to the fundamental right to vote. So our charter grants full effect to the right to vote by providing for nonpartisan primaries and elections, the initiative and referendum, the recall, initiated charter amendments, and progressive approaches to elections administration. In reserving these rights to the people, our charter attempts to map an equitable path to exercise these rights. But so much has changed since our charter was adopted in 1914, and provisions related to these rights have not, in many instances, kept pace with evolving best practices. As a result, various charter provisions are outmoded, such as the ballot form and layout. Various provisions are inconsistent, such as the signatures for referendum and initiative. and various provisions are out of step with best practices, such as requiring that recall petitions only be signed at the various fire engine houses of the city or the city clerk's office. With this in mind, staff reviewed the city charter, current state law, and recognized best practices in an attempt to recommend modernizations for the elections provisions of the charter. Staff has developed the following recommendations based on the firm belief that every Columbus citizen must be able to clearly, consistently, and equitably exercise their voting rights. Before diving into these recommendations, there's a really simple question we could ask. Why don't we just default to state law when it comes to elections? First, we've seen a concerted effort to erode voters' rights in state houses across the country. As the former Director of Policy and Research for the Ohio Secretary of State, I can attest to the disenfranchising effect of these state laws and the controversy surrounding them. Ohio's current election laws, passed over bipartisan objections, make it harder to cast a ballot and have it counted, unnecessarily intrude on local government's authority to promote voting, and put up unnecessary hurdles to the ballot box for petitioners and potential independent or minor party candidates. These laws effectively erect barriers around select voters, ignore common sense bipartisan regulations, and manipulate the elections process for partisan gain. And I would note that unfortunately both parties are guilty in this manner. Second, many state laws, provisions regarding municipal elections have been unchanged since the 1950s, while those for state issues and elections have, for the better or worse, been consistently updated. As a result, state law for issues like a charter amendment presents citizens and elected officials alike with a dizzying maze of less than consistent provisions. Third, adoption of our strong home rule charter took place against the backdrop of constant interference by the Assembly in the affairs of local government. The charter's framers intended, and staff recommend, that we fully exercise in a responsible manner our home rule authorities in the arena of elections. Because the Home Rule Authority plays a critical role in this process, I would defer to Josh Cox to make a few comments about the background of that issue for the Commission.
As the Commission will remember, in our first meeting, under Home Rule, we have the authority under local powers of local self-government to determine how our officers of the city are elected and to determine matters that only affect the city and the city's ordinances, which include initiative, referendum, recall, those types of matters. So that is a matter of local self-government. So we can enact procedures as we deem fit through our charter that basically determine how that process takes place. Keep in mind we have the section 232 of the charter, which talks about general laws applicable to the extent they don't conflict with the charter or ordinance of the city. So we have incorporated the general laws of the state relating to elections into our charter to the extent that they don't conflict with the charter. So you have, we have incorporated those general laws. So the issue then is how do we want to differ from those state laws, or how do we want to fill in the gaps that are left by state law? And that is entirely within the discretion of the city as a matter of local self-government.
So conceivably, speaking as Director of Kids Voting, we could allow 16-year-olds to vote in municipal elections.
Correct. Conceivably.
Okay.
So based on the foregoing, staff recommend adopting general laws of the state where common sense provisions have been firmly established while enshrining in our charter those modified provisions that best protect citizens' voting rights. With that, I go through sort of the general provisions where we are recommending changes. This is an overview of those items. We've also provided to the Commission a draft of the actual charter amendment, if you'd like to look at 2 pages at once. So in general, elections are conducted under the general laws of the state, but we are recommending that there be an explicit exception unless that is otherwise provided by the charter or ordinance of council. This gives us the discretion and the authority to fully exercise our home rule authority with regard to elections And in the event of a dramatic change to an item that is in general law, for example, the requirement that the names of candidates be rotated on the ballot, were that to be removed, council could swiftly act to ensure that that did not impact the ballot for city elections. We would recommend that we maintain nonpartisan elections by the secret ballot and maintain every citizen's right to vote for every elected official in their city government. With regards to campaign finance, there was an amendment that was adopted by the voters that expressly gave council the authority to adopt campaign finance regulations. Council has used that authority to enact stronger disclosure provisions than state law requires for candidates for elective office. However, it does not explicitly reference disclosure requirements, and given the recent rulings of the U.S. Supreme Court and the general national sentiment away from restrictions, right or wrong, that is the direction the court's headed, we think that it would be justified to expressly state in our charter that the intent is that council can also pass ordinances with regard to disclosure requirements. Further, our charter only applies to elective officers. It does not apply to ballot issues. And while there are limitations on what council could do with regard to donations to ballot issues, council certainly could look at better disclosure requirements. For example, a ballot issue committee organized under the IRS code, depending on the section of code, might not file their 990 for 2 or 3 years. We want to be sure that we can, where we feel appropriate, provide citizens with better access to information about who's seeking to influence their vote. As far as ballots are concerned, our charter has very lengthy ballot forms and, place an X here and things like that. Things that made a lot of sense when our charter was first adopted, but really don't make sense given where state law has moved to this point. So we would recommend that we eliminate all ballot forms in the charter. That is adequately and appropriately covered by state law. With some additions, and most specifically, this is a cost-saving measure, providing that summaries of ballot issues will be placed on the ballot versus the full text. The revised code provides an either-or, and in the event that there is a summary provided, the full text has to be placed in the voting location as well. We feel that because of that safeguard in state law, that providing a summary is probably of more use to voters. And for those voters that would choose to read the entire amendment, they would have the ability to do that either online or at the voting location. We would also recommend that we retain the ability to make modifications to the ballot by charter or by ordinance of council, again, in that extraordinary circumstance where council needed to act to protect a provision that is currently in state law that might be removed by a future vote of the General Assembly. With regard to nominating petitions, the state law nominating petition for nonpartisan candidates is actually quite good. It, we think, appropriately covers the items that are currently in our charter that we would recommend retaining, but this would also allow us to make a few tweaks. One would be maintaining the requirement that a candidate submit 1,000 valid signatures in order to make the ballot. Staff looked at other large cities in the state, and if you look at the number of signatures required as a percentage of their electors, the average is about 0.25% of the electors of the city have to sign a nominating petition. 1,000 signatures in Columbus would be approximately 0.2% of our electors. So we feel that this really does put us in the mainstream with other Ohio cities and would be an appropriate bar, given our nonpartisan elections, to the ballot. We would recommend that we eliminate the requirement that signers pledge to support a candidate. This is something that a citizen recommended at a previous public hearing. His recommendation was well taken, and that's something that staff would recommend for your consideration. We'd also recommend removal of the archaic requirement that a candidate accept their nomination. This was based on the turn of the 20th century and the idea that you're going out and you're really trying to draft someone to run for election. That's simply not the way that nominations work now. We think that the fact that a candidate under the state law provisions would firmly establish they are a candidate for that particular office obviates the need for this requirement. We would also recommend that the charter be adopted to add disqualified to the provisions regarding death and withdrawal as conditions to replace a candidate in primaries and generals. And rather than using the current deadlines and processes that are in the charter, which are really in this instance have been well established by state law, default to state law for the deadlines and the processes for withdrawal and replacement. So really, when it comes to ballots and to nominations, these are areas where there's been very little significant controversy at the state level, and both the Secretary of State and the Board of Elections can do a very good job of providing some clear guidance for any citizen who wanted to run for office. Then we move to petitions for ordinance, referendum, recall, and charter amendments. I begin by saying that the general laws of the state are virtually silent when it comes to a charter amendment petition. We are able, because of the way that they're written, to sort of cobble together what would be intended for that type of petition, but there is nowhere near the clarity in general laws for a charter amendment that there is for a petition for ordinance, for referendum, or for recall. So first of all, we would recommend that we reorder our charter to provide for uniform general provisions, including templates for these petitions, so that any individual who wanted to initiate an ordinance, a referendum, a recall, or a charter amendment could contact the city clerk and could receive a petition that has been reviewed by legal counsel and determined to be legally sufficient as to form. We think that this will remove fighting over whether font was in the right color and other provisions that are in state law that we have no option but to follow, but really are not the intended purpose of the initiative or the referendum. The intended purpose is that the legislative branch has not acted in a manner that certain citizens find appropriate, and they want to act for themselves. And the focus should be on the sufficiency of their signatures and on the validity of their request versus the sufficiency as to form. We would recommend some modifications to the state law for municipal petitions. This is primarily driven by the fact that state law for municipal petitions has not been updated in most instances since the 1950s. And it is not very easy to harmonize the general provisions of state law with the municipal provisions of state law. So we would recommend some updates, such as requiring that part petitions be circulated as a single instrument. Obviously, a petition has to be submitted as a single instrument, but there have been instances in other cities where, because of the form of the petition, it was not at all clear that the signatures that were attached to the language were actually signed for that particular petition. I'll give an example. The petition form doesn't require that the title be placed at the top of every page. So a person could arguably circulate a petition saying that puppies are great, and you sign it thinking that puppies are great. When they turn it in, they've turned it in for a wholly different purpose. And there would be really, it would be very difficult for the city to know that. So that's why we would also recommend that a title must be placed without argument at the top of every page of every part petition. So it is very clear to the elector and to the elected officials what they signed for. The purpose of without argument, council ordinances go through a very extensive review process that simply doesn't exist in an initiated ordinance. With an initiated ordinance, 5 people can sit in a room, decide what they think the law should be, and then submit it as a petition. So there really isn't that check and balance on things like accurate and appropriate titles. We would also recommend that the full text must appear on the petition. For referendums, that is not required under state law. We think that that's a defect in state law, and that a person by title alone may not adequately understand what petition they're signing. So providing the entire item to be repealed We think that will give voters a better sense of what they're doing. And then lastly, for state issues, the circulator statement has to disclose payment for circulation. For municipal issues, it doesn't. We think that it makes sense that if you're being paid to circulate this, a signer would approach that person differently than an interested citizen who believes strongly in the item that they're presenting to them. We'd recommend that we would harmonize requirements for state laws and municipal ballot issues, and that you would file a statement of intent to compensate and a report of compensation at the beginning and at the end of a petition process. Under our current charter, it would appear that a person can physically withdraw petitions that have been filed with a public office. Those petitions are a public record. So while we agreed that a petition issue should be able to be withdrawn from consideration, the petitions themselves should not be able to be physically withdrawn once they're filed. We would also say that there should be consistency in who you file this with, and we think that the most appropriate person would be the city clerk for both a certified copy and for the final petition itself. We would recommend that the charter clearly establish the duties for the clerk, the council, the city attorney, and boards of elections when it comes to processing petitions. The initiative is not nearly as frequent at the local level as it is the state level, and sometimes we find ourselves reinventing the wheel when it comes to exactly what we need to do when one's been filed. This would take care of some of that for us and provide some consistency and continuity. We would recommend that state law control for the circulation and the validation of signatures, with some very limited exceptions. The first would be that signatures could not be collected prior to filing a certified copy. The process for a state-initiated statute is actually fairly smart in that you have to show public interest. You file this with the Attorney General. If he or she approves it, you can then move forward with circulating your petition. This would simply provide that there would be no question that a uniform petition was circulated, and it would also provide that you would have 1 year to file a petition or for an ordinance or for a charter amendment after you filed your certified copy. This is modeled after state law provisions for petitions, and we would recommend maintaining the 30-day window to file a referendum or a recall after filing the certified copy. The purpose of the 30 days for a referendum is that that's the time period where a non-emergency ordinance would go into effect, and the purpose for the recall is so that you don't essentially have a political circus where someone claims that they're going to recall an elected official. They have no intention of doing it, yet they continually circulate the petition, creating a lot of unnecessary controversy in the community. We would recommend that council, as a body that is accountable to the electors, should determine the sufficiency of all petitions. Under our current charter, it's actually the city clerk that determines the sufficiency of certain petitions. We would, however, recommend that we maintain the city clerk's authority to determine the sufficiency of a recall petition, so that there is never any conflict of interest between the individual certifying and the person who is potentially the subject of the recall. And then per case law, council's action by ordinance on petitions would not be subject to the veto or subject to the referendum, because these are administrative or ministerial actions, not purely legislative actions. When it comes to the initiative and the referendum, we would recommend that there would be the requirement that 5% of the votes cast in the last mayoral election be the standard. Under state law, the standard for an initiative or a referendum is 10% of the votes for governor in a municipality. If we adopted that, you would need more signatures to place an initiated ordinance on the ballot than you would a charter amendment, which seems counterintuitive at best. Under our current charter provisions, you need 5% of the last municipal election. This creates a lot of uncertainty for voters. You can come in after the off-year election and get fewer signatures to put something before voters. That's why at the state level and in most cities, there's a 4-year time period during which you have a consistent number of signatures that you need to propose these things. We would recommend that the Board of Elections be given 10 days to validate signatures. That would be in line with state law. We would also state that council has to determine the sufficiency of the petition within 14 days of the board report. State law is silent on municipal initiatives for the time frame for action, and the action is actually not by the council, it's by the, I think it's either the auditor or the village clerk, if I remember correctly. Council would then have 30 days to pass or repeal or submit this to the voters. The charter currently provides that council has 7 days, essentially, to consider an initiated ordinance or referendum. And I think that council owes it to the voters to provide a reasonable period of time to consider what they put forward, whether it's a good idea, a bad idea, and really thoroughly vet it as opposed to rushing to judgment as we have to under the current charter. Council would have to prescribe a ballot summary and may prescribe arguments for and against that could be placed in the voting locations. And then we would clarify that there are ordinances that are not subject to the referendum. One archaic reference is the annual appropriation ordinance. There is not a single annual appropriation ordinance currently in the city, so we would instead refer to the annual appropriation ordinances, plural. And then ordinances submitting a proposal to electors would also be taken away from the recall. For charter amendments, really the specific changes to the charter amendments would be very minimal. They would primarily be with regard to the petitions and to prescribing ballot summaries and the permissive ability to prescribe arguments for and against a charter amendment to place in voting locations. Probably the most substantive change would be for the recall. We would recommend adopting a modified version of current state law, although our charter and its archaic reference to this, the firehouses of the city, it actually does say that that is in addition to any other provision of state law for the recall. So we took a look at the state law for the recall, and it is really not in keeping with the spirit of our charter, so we would recommend removing that reference and better addressing this issue directly in the charter. So we would maintain the requirement that petitions have to have 15% of the votes cast the last regular municipal election for mayor. You would not be able to file a recall petition within 180 days of someone taking office or within 90 days of a general election for office. We would recommend that for the purposes of continuity of government, that no more than 3 elected officials could be recalled at a single election. Currently, you could recall every elected official in the city of Columbus at the same election. The city clerk would maintain his or her authority to determine sufficiency of petitions. We would recommend maintaining the requirement that vacancies after a recall be filled as otherwise prescribed in the charter. And then there are 2 additional considerations. One goes to Commissioner Cabot's point about allowing 16-year-olds to vote. We have a provision in our charter regarding campaign finance because the city of Cincinnati enacted a campaign finance ordinance, and it was struck down by the Supreme Court because they said their charter did not give them the authority to do this. We think it is worth considering whether we should establish voting as a fundamental right in our charter. This would do a couple of things. It would allow the city to protect voter rights either through ordinance or through legal action. It would allow the city the permission to expand voter registration and participation. And it would allow the city the ability to promote nonpartisan voter registration and participation. We also recognize in raising these issues that we raise them for discussion, not for recommendation, because this would be a sea change in the way that the city approaches elections. But it is our feeling that that's a discussion whose time may have come for the city of Columbus. In addition to that, when our charter was first adopted, there was a 2-year sunset provision on any item that was initiated ordinance or initiated referendum. The idea being that the vote of one single election should not for all times tie the hands of the city of Columbus. That provision was removed with the amendments to the initiative and referendum in 1933. We think that it at least merits discussion, as a previous Charter Review Commission has recommended reinstating a sunset on the citizen-initiated ordinance or referendum. Again, we raised this for discussion, not for recommendation. We think that it would be a very significant change to the way that we approach the initiative or referendum, but one that may be appropriate for the city of Columbus. I've just thrown a lot of information at you, and I apologize. I worked in the elections arena for a very long time, so unfortunately a lot of it's up here. So if you have any questions, I'm happy to answer them, or if there are any questions that come up after you've had a chance to digest this, I'm always available.
So you are not seeking commission action today on this proposal, or you are?
I think unless the commission feels that it would be appropriate to take action on it, I don't think that it would be appropriate for staff to presume what the commission should do on something this weighty.
There's an awful lot here. Questions or comments?
I have several questions. I don't know.
I do as well. There's a lot here.
I think we need to peruse this. The last section is the Bethel Morse Connector amendment, right? Yeah, we need to take this as a homework assignment.
Yeah. So noted. What is the will of commission and staff about conducting any other business today? We had residency as an item that was added. Is that something we should deal with today, or?
To the commission.
We should be able to dispose of this quickly, shouldn't we?
Okay, well, let's.
So maybe we can get through the conversation, or at least I can give the background and then.
Proceed.
Okay. Thank you, commissioners. This is again on employee residency requirement. Until 2009, employees of the City of Columbus were required to live within Franklin County or a contiguous county based on Section 158-1 of our charter. In 2006, the state adopted Ohio Revised Code Section 9.481, which states, "No political subdivision shall require any of its employees, as a condition of employment, to reside in any specific area of the state." The statute did have the following exception: to ensure adequate response times by certain employees of political subdivisions to emergencies or disasters, while ensuring that those employees generally are free to reside throughout the state, the electors of any political subdivision may file an initiative petition to submit a local law to the electorate, or the legislative authority of the political subdivision may adopt an ordinance or resolution that requires any individual employed by that political subdivision as a condition of employment to reside either in the county where the political subdivision is located or in an adjacent county in this state. Two other exceptions that were also in there dealt with volunteers and those who were employed on less than a full-time basis, and in both of those, the residency requirement was not applicable. Both the City of Akron and the City of Lima filed separate suits to continue to enforce their residency requirements for their public employees. They both argued that the statute violated their home rule authority granted to them in the Ohio Constitution, which Josh just talked about as we went through the election piece. In Lima v. State of Ohio, 2000, Ohio 2597, the Supreme Court upheld the statute, saying that it superseded contradicting local laws. The court found that the state had properly exercised their powers in creating a law that gave public employees more freedom in their choice of where to live, regardless of where they were employed. The Lima decision has left our charter provision unenforceable. Therefore, this commission has 4 options to consider given the current state of the public employee residency law. The first one is to retain the current charter provision, which could become operative again under revised state law or a different court decision. Number 2 is to remove the charter section with no replacement language. Number 3 is to remove the charter section and suggest that City Council introduce an ordinance to enforce residency requirements for emergency personnel based on the statute language. And number 4 is amend the existing charter section to enforce residency requirements for emergency personnel based on the statute language. And just on the back is just our current charter provision.
Comments and questions about residency?
I would support number 1, only because I recognize the unenforceable portions today, but that can change, and this is a section that has worked pretty well.
Mr. Dorian, to your point, Brian and I were talking earlier, and Brian brought it up earlier, that section number 12, which today we've asked this commission to consider removing regarding the public defender. A commission in the past made a similar recommendation to go ahead and keep it in there to see if anything did change between now and basically the next commission. So there would be precedent for doing something like number 1.
Thank you, I didn't know that.
Other comments, questions?
I would support option number 2. I think that your interest is in getting the best, most productive city employees that you can, and that making Columbus an attractive place to live is more than just requiring city employees to live there.
I don't have any strong objections to that, by the way.
I have a philosophical problem with keeping charter provisions in that have been rendered moot. I think one of the objectives is to have a clean working document that reflects the realities of the times, and that dead soldiers should be taken off the battlefield. And current charter provision is a dead soldier. Marshall or Don, any thoughts, questions for others?
And it is the end of a long day, so if we want to defer this until next time, maybe that's the right thing to do.
Yeah, but let me reiterate, I'm not in concrete on my thought on this. I can accept Jeff's thought, but at the same time, certainly listen to yours.
Staff okay with us deferring this until
We very much appreciate your willingness to stay later with us.
this is represents an awful lot of work, and so for the commissioners and staff, thank you for your diligence and for no one falling asleep during this long.
That's because we kept everybody cold.
On the announcement of future meeting dates, I'm going to leave that to you, Brian, so I don't mess it up.
So the next regular meeting of the commission will be the 26th from 1 to 4 p.m. There will be a public hearing on the 26th from 5 to 7 p.m. Public notice will go out on that, and it's our recommendation that speaker slips or slips for public comment be accepted up through 5:30 to recognize that there may be a lot of public interest. There may not be. So we feel that that would be an appropriate time to do that. And then the next commission meeting after that will be the 30th from 12 to 3 p.m. Ish.
Is there any other business? If not, I will entertain a motion to adjourn.
So moved.
All in favor? Aye. Thank you. Just a thought on